My lord, may I have a kind leave, my lord, to file a revision application without certified copy? Because, my lord,
What is the urgency?
urgency is this, my lord. This matter was heard before lordship, before the puja vacation last year by my lord, learned senior counsel, Banerjee. Then, my lord, your lordship has passed an order of stay. They have referred and registration application through the order of the learned trial court
Have you
below.
given the server copy?
Yes, I have given.
All right.
Kindly, my lord, grant the leave.
Yes.
With your lordship's leave, my lord, I was
Huh?
mentioning item number 98 of today's list. I'm handing over the copy of the last order. My learned friends are also here. This is that matter, my lord, where Mr. Banerjee had opened his argument, and my lord, Mr. Krishnaraj Thakkar, who was appearing here, or because this is the order where personal appearance was directed on 3rd of next month, and when this matter was adjourned, kept only for today for Mr. Thakkar to take instruction. Lordship,
Yes.
because the matter
This
is
matter
gone
is not appearing.
98 way bottom. Can I come at 1:12:30 just for 10 minutes? It will
Please see.
kindly give him. Otherwise, Lordship, because on 3rd we have been directed to appear. But this is that matter where Lordship.
3rd of September.
Third, because on the very first day order was passed, ex party directing personal
All right, I
appearance.
will consider.
So Lordship may kind indicate if any time is indicated. Lordship 12.
Today it may not be possible. I will consider this. Yes.
Then
Friends request, I am also in item 98. I was hoping that I come from Delhi for this matter. Whatever time is convenient to my lord, we'd assist the court and my lord can pass it out.
it will not take much time, my
It
lord.
would not take, really would not take much.
All right, come tomorrow.
Tomorrow.
Tomorrow morning.
Any specific?
I will fix the time.
Lordship.
Yes.
Item number 18 of interim order, lordship.
Extension of Vinchimar, please hand over the slip. Please indicate when it is expiring.
Permitted to mention item number 88 of the combined list, 29 date fixed for depositing the police call.
Hand over the slip.
Item number 174, Lordship. Tomorrow 12 p.m. Lordship is fixed for Lordship. Police help Lordship for handing over the position, Lordship.
Hand over the position. 144 is
Lordship,
there.
I am the Lordship, Borgadar Lordship, without making us property, Lordship, party Lordship, the decree was off.
Hand over the position. We will get back if you
Now, Lordship, order 97, order rule 9, 21, rule 97, Lordship, without Lordship hearing the miscase was disposed of.
Order 21, rule 97. How it's a revisable order?
Now, Lordship, misappeal has been paper, Lordship, stay has been refused. Against that, Lordship, we have preferred this revisional application.
Item number
174, Lordship.
174.
Tomorrow, Lordship, 12 a.m. Lordship is the fixed for Lordship handing over position, Lordship.
174.
CO 2591, Lordship.
2 p.m. Yes.
One new motion. In a private endowment, the Indian Trust Act has been applied. Your Lordship, there is no other side because there is no opposite party. Private endowment, the division bench of our High Court has made it clear that Trust Act will not be applicable. This is a new motion, but if your Lordship takes up any
New motion. When have you filed?
appearing as 1960.
For inclusion, please mention on Monday.
Appearing 1960.
For upgradation, please mention on Monday.
May I have your
My lord, may I,
to file Lordship one leave to file Lordship on 31st Lordship. 31st Lordship of August.
May I
my lord, may I be permitted to mention one matter for correction, please?
Corrections, please.
214 Lordship, this today, the bank is proposing to sell the property after
214 of?
214 of the list of today.
Yes.
214 I'm mentioning upon notice. The bank is contemplating selling the property on Saturday. This is the notice. The bank is on notice. I've served them. It needs to be taken up. 214.
It's already appearing under the heading upgraded matters.
Bank is selling the property day after tomorrow. I have the notice.
Day after tomorrow. All right, let me see.
Lordship,
Please hand
item
over the
number
slip.
156.
May I have your
Lordship, item number 156 from today's list, Lordship. The interim order has expired on 25th of August, Lordship. But the matter was not taken up. Kindly, if your Lordship takes up the matter today.
Please hand
At
over.
2, Lordship. At 2.
For extension, please mention.
May I have your Lordship's kind leave to mention, my lord, item number 76 of your Lordship's days list, my lord.
Yes.
But here, my lord, I have already pointed out earlier, my lord, but the Honorable Green Tribunal is wanting to proceed against the by deleting the name of the actual polluters from the array of the respondents in the application, my lord. And
Hand over the slip, please.
my lord, already, my lord, I had handed over the
Then
slip,
you did not hand over.
but only one request, my lord. But six.
Have you ascertained what is the endorsement in
on
the
three
mentioning
occasions,
slip?
my lord, on 3 occasions, my lord.
Have you- Please, last when did you mention?
My day before yesterday, my lord. Day before yesterday, my lord.
Monday.
My Monday, my junior
Monday,
is here.
please
Yes, Monday,
ascertain-
Monday.
Please ascertain what is the endorsement in the mentioning slip. Please ascertain from my officers. Don't hand over. Please ascertain what's the endorsement made on the slip, handed over on Monday. Yes, Mr. Bhattacharya.
This is not something very professional. It is concerning, the matter, which is appearing as item number 50. I am paying for sending it for a settlement. It's an expeditious hearing, essentially, expeditious hearing.
Item 50.
50.
Yes.
I was humbly beseeching your lordship.
Who is for the other side?
I have served notice, despite there being no caveat, it's a brother-sister dispute. I tell you, I need not tell your lordship something beyond this. I was only beseeching, if it can be, placed under the heading to be mentioned any day convenient to the court, we will be paying.
We mentioned Kalke diye dit 50.
Great.
Yes.
Your lordship.
Only one thing I would like to add, my lord, subject to your lordship's permission, my lord. 16th is the date fixed. I am quite mentioning on advance. Any day, my lord.
Sir, if you have mentioned on Monday,
Yes, my lord.
please check up what is the endorsement.
I will. Immediately, my lord.
Item 50 mentioning slip.
My lord, this is Wakaf dispute property, my lord. The civil court will entertaining this same, my lord, beyond this.
Hand over the slip. Yes.
My lord, one.
Tomorrow is the date, learned.
Maybe. Please hand over the slip.
The DRT holds that the demand notice has not been served, but now the section 14 passed. The order of eviction is upon me. On the last week of July, my lord, notice for eviction has been given. Kindly hold. Admittedly,
I have your lordship leave to seek leave, my lord, to file a revisional application without the certified copy, my lord.
What is the urgency?
My lord, actually, my lord, the other side has also preferred an application, my lord, which is listed in my lord's list as item.
Please file it for that take leave. Please file it. I will consider.
Yes, lord.
The date is tomorrow.
Please hand over the slip, madam. Yes. Call the list.
But
My lord, there's one extremely urgent matter. 31st, my lord, the date for inspection.
What is
Lord.
inspection?
Commissioner, with respect to, my lord, in a matter in the.
Hand over the slip. Yes.
Sir, we've said all that. Can you seize the date of the inspection?
All right. Please hand over the slip. Yes. Call the list.
Edeki. Oh,
Yes.
my lord, this is that.
Choose, Mr.
Haldia-
Chatterjee, which one is more urgent.
Haldia port matter.
Only
my lord.
one. Please choose which one, because you know the best. Which one is more urgent than the other?
My lord, the Billa, I'm not Billa. This is the Haldia port matter. Your lordship remembers, my lord, section
Which one is
7.
more urgent?
Both
The
of
one
them.
you have mentioned before or the next one?
No, that was because
In
of
order of priority.
no, my lord, whatever came first. The only thing is, my
Hand over
lord,
the slip. Yes. Call the list. Yes, Mr. Bose.
A copy of the Supreme Court order. This is the reason why your lordship recollects that Court 19 abatement partnership for.
Yes. Now what happened?
Lord, the order of abatement, Lord, orders seeking abatement.
We are of the view that let the High Court
for
hear out the
denying
main appeal itself on its own
the
merits.
Supreme Court affirmed my Lord's order and directed the appeal to be heard on merits.
Well, our understanding of the order is otherwise. Anyway, your lordship will
Yes.
decide.
Please, you can make your submissions.
No,
What
nothing.
you want to mean from the order?
If your lordship will see paragraph 2 after recording in the second page, we are of the view that let the High Court hear out the main appeal itself on its own merits. Then let the appeal be taken up for hearing and be decided within the period of 2 months. It shall be open for the parties to raise all contentions available to them in law. This is the problem.
Yes.
Anyway, it has to be heard, whatever. Then please decide.
It-
The only difficulty is that, Bernard, I can appreciate Bernard, but that paragraph 3 is
Yes. When can both of you come?
Lord, any days, Lord, except coming Tuesday.
Except coming Tuesday. কালকে কি রকম আছে?
Wednesday. Well, would your lordship also include Wednesday with that? Tuesday and
I'm
Wednesday.
thinking of tomorrow.
I thought as much.
I'm not going to the next week.
Told by juniors. My lord, maybe start from Monday. Monday.
Friday is a good day, Mr. Auspicious day, Mr. Bose.
Friday is Raksha Bandhan. Lordship will spare
That's
Raksha
why I'm
Bandhan.
telling her it's an auspicious day. You want Monday, Mr. Chaturvedi? Uh, who is the appellant?
And
You are the appellant. How much time you will take?
1 hour.
1 hour. Mr. Bose,
I will take longer.
how much? Please give me an impression.
My lord, if your lordship is with me, I will not take more than 5 minutes.
I'm with both of you. I'm with both of you. Yes.
Very difficult, but lordship will
Please,
give us a few hours. At least a few hours, because
few means, what's the meaning of the expression few?
If my lord is not with me in the next 1 hour, I know my lord will not be with me.
How much? So that, Mr. Bose, I have
I
to.
can understand.
That is what I'm asking you.
Kindly give me, my lord, about 2 hours.
2 hours.
Let's start on Monday. If my learned friend finishes on Monday, and your lordship will give me a few days thereafter.
If he finishes, Mr. Bose, you have to start. Don't wait for because time. If time is left, you have to start, Mr. Bose. Please prepare in that way. This matter was mentioned.
Aisha.
Yes. Next.
He'll finish. He's the appellant.
Yes. Anything more, Mr. Bose?
Hello? No, 3 p.m. I have a fixed matter. So Mr. Chaturvedi will continue. I will join in.
Yes. Next. What is the can for?
What has been disposed of by you?
Can disposed of?
There is just one can.
One can is of 2010, another is of.
I think there was
2025.
one can for impediment.
Please check up. Yes.
There's one
Next.
intervention application process.
Yes.
Lordship, I'm on behalf of the petition laid by Mr. Shami Mohammed. I'm on behalf of the petitioner.
You are for the
Petitioner.
petition is appearing in person.
Respondent, Your Lordship. I'm just being instructed to pray for time. Mr. Ahmed is not ready with the matter, Your Lordship.
Which matter?
Is for the
Item number two.
Case number?
is for the opposite party.
Yes, Your Lordship. Opposite party.
Or item number 2. Are you sure?
That's I've been instructed. I think.
You are for the opposite party.
Yes, Lordship. Case number?
An accommodation, the petition.
My lord. In which
Misunderstanding, Your Lordship.
Yes, you are appealing to the opposite party.
Yes, my lord. We are.
Yes.
My lord, kindly turn to your lordship's order dated 22 April 2025. That is the first order of the CO application, my lord.
Yes. Twenty-second of April
April
2025.
The first order of the CO application, my lord.
Yes.
The opposite parties had raised issues for the maintainability, my lord.
Yes.
And for that, thereafter, the another coordinate bench directed me to file a compilation of judgment on the issue of maintainability. And therefore, I have already filed, my lord, compilation, that is the corrected version, volume 1, my lord. It's approximately 100 pages.
Yes.
And also I have filed, my lord, volume 1A, my lord. I have also served the relevant copies. And today I am going to file another compilation, my lord, volume 1B. I've served all the copies to the other side, my lord.
Yes.
Now,
Yes.
my lord, the issue of maintainability, there is a judgment by name Shukhendu Maiti versus State of West Bengal. Kindly come to my compilation, volume 1, my lord, judgment number 5. Volume 1, corrected version, my lord. Volume 1, corrected version.
Volume 1 corrected.
I'll cite you the page number, my lord.
Yes. Please first place the impugned order first.
My lord?
First place the impugned order.
Okay, my lord. My lord, page 44, my lord. Annexure A.
Yes. Yes.
My lord, then kindly refer to, my lord, the order dated 30/11/22, my lord. That is having a connection with this impugned order, my lord.
Page,
my lord. Yes, my lord. Page 79 is starting. I want to cite, my lord, at page 80, my lord. Kindly turn to page 80, the relevant portion, my lord, that is connected with this part, with the impugned order. My lord, in the middle, my lord, third paragraph, the paragraph starting with considering. Let me read, my lord. Considering the pleadings relating to the allegations and counter allegations of the parties, which are strictly tribal issues, cannot be dealt with at this stage, plaintiff has filed temporary application, but the prayer embedded in it is in the form of mandatory injunction. Already dismissal order has taken effect after issuance of suspension order, and those are under challenge, and the suit has been filed for declaration of the suspension and dismissal order to be void and not binding upon plaintiff. Therefore, at this stage, there is no scope to grant an order of injunction restraining defendants from withholding the subsistence allowance. There can be restraint order with respect to a function which is still continuing, but there cannot be any restraint order with respect to the function which has already stopped. My lord, this is the nature of the relief that was prayed in the order 39 petition, earlier injunction application that was disposed of on this date.
Yes.
The nature of the relief was, my lord, does not comes under the ambit of order 39, and this was already iterated by the trial court, my lord, learned trial court. Therefore, I have preferred the 151 subsequent 151 application which is having the nature of relief of the interim mandatory nature coming under the purview of the inherent jurisdiction of the court, Planet Trial Code under section 151 CPC.
Where is the application?
My lord, that 151 application?
Yes,
Yes.
yes.
Annexure E, my lord, page 82 of the CO application.
Yes. The prayers are at page 101.
My lord, prayer is at page 101.
Yes. Yes.
My lord, now come to the corrected version, volume 1, compilation of judgment, page number I'm citing, my lord. Page number 84, my lord.
Yes. Page 84.
Yes, my lord. The corrected version, my lord.
Yes.
My lord, I'm not reading the facts to waste the time, my lord. I'm just coming to the at page 87, my lord, para 10.
Yes.
At the very outset, we make it clear that although the second application for injunction is, before that, let me iterate a little bit of facts for this case, my lord. In this case, order 39
Please place this paragraph.
My
Yes.
lord, little bit. Otherwise, it will be difficult to interpret, my lord. Because in this case, there was a pending order 39 application, and the nature of relief prayed in that order 39 application was under the ambit of order 39 application. And during that pendency, a subsequent application under 151 with the nature of relief under the order of ambit of order 39 was filed. And in this regard, this honorable court had passed this ratio, my lord, ratio of the law. At the very outset, we make it clear that although the second application for injunction is described as one under section 151 of the code, in reality, the prayer made therein clearly comes within the purview of order 39 rules 1 and 2 of the code. And as such, this appeal should be held to be maintainable as the order impugned comes within the scope of order 43 rule 1R of the code. It is now settled law that in deciding the question whether a particular order is appealable or not, the court should not be guided by the wrong quotation of the provisions of a statute by the court in the order impugned, or by such wrong description given by the parties of an application upon which the order was passed, but the appellate court should find out the exact provision of the statute which authorized the court to pass such order. Applying the aforesaid test, we find that order impugned really came within the order 39 rules 1 and 2 of the code, although wrongly described as one under section 151. In this case, therefore, this appeal was maintainable, my lord. But as I've already cited, my lord, at the very beginning, my nature of relief in the original order 39 application does not come under the order 39 ambit CPC. But in the nature of 151 application, it is coming under that one. So in this regard, this judgment is not overpowering my, is not acting as a contrary for my case, my lord. Now, also, there are Supreme Court judgments, my lord. Next, I will cite, my lord. Kindly come to my compilation, my lord, volume 1A, my lord.
Volume 1A.
Yes, my lord. Small, very thin one, my lord. That was submitted on last 9th of June, my lord.
There are two, volume 1, this is 1B. 1B is 2, where is 1? A.
1A, my lord.
Yes, 1A.
My lord, the judgment is delivered by the Honorable Supreme Court, my lord. It is the Sangeeta Singh versus Union of India and others. Citation is given in the compilation, my lord.
Yes.
Kindly come to page 4 or running page 4, my lord, of the compilation. Para 1.1, my lord, held.
Yes.
Courts cannot read anything into a statutory provision or a stipulated condition which is plain and unambiguous. A statute is an edict of the legislature. The language employed in a statute is the determinative factor of legislative intent. Now coming to the next para, my lord, under 1.2, the highlighted portion. The object of interpreting a statute is to ascertain the intention of the legislature enacting it. The intention of the legislature is primarily to be gathered from the language used, which means that attention should be paid to what has been said as also to what has not been said. Now why I've quoted this, I'll come with my next judgment, my lord. The aforesaid principle is relevant to the present issue, as to that the artificial creation of a statutory right of appeal cannot ordinarily be achieved by judicially reading into Order 43 Rule 1R, a category of order which the legislature has not expressly made appealable merely on the basis of similarity in the nature of relief sought. What I meant, my lord, if we see the CPC, my lord, Order 43 Rule 1, which is the actual provision for filing a misappeal against the order of Order 39, any order passed under Order 39, Rules 1 and 2. There are 24 clauses, my lord. In none of the clauses, my lord, there is a provision mentioned that any order which is in the nature of an injunction may be appealable under Order 43 Rule 1R. Now coming to my next judgment, my lord. That is again in the corrected version, volume 1, my lord, judgment number 4.
For what proposition? For what proposition?
Yes, my lord. I'll tell, my lord. Here the proposition in this judgment, my lord, it is saying the Honorable Supreme Court reiterated that the inherent jurisdiction under Section 151 CPC is intended to supplement and not to replace remedies expressly provided by the CPC or any other statute. However,
which judgment you are referring to?
My lord, the judgment number 4 from my volume 1 corrected
All
version.
right.
Page
78.
Yes, my lord, 78.
Yes.
Kindly come to, my lord, page 80, my lord, the highlighted portion.
Yes. Yes, I've seen.
My lord, I'll just pronounce the gist, my lord. What is the judgment is State of UP and others versus Roshan Singh by legal heirs and others. However, this Roshan Singh judgment does not lay down the inherent jurisdiction under Section 151 CPC, becomes unavailable merely because an earlier application under Order 39 Rules 1 and 2 CPC had been invoked and rejected. In circumstances where the court had found that the particular situation or interim relief sought did not fall within the scope of Order 39 Rules 1 and 2 CPC. In the present proceeding, the order dated 30/11/2022 passed in the pending suit, particularly the third paragraph, which I read, my lord, in the 30/11/22 order. Plaintiff has filed temporary injunction application. That my lord, I've already read. I'm not reading again. The aforesaid finding clearly indicates that the learned trial court did not merely record the absence of the ordinary ingredients for grant of an injunction under Order 39 Rules 1 and 2. Rather, it proceeded on the basis that the nature of the relief sought was a mandatory interim restorative relief, arising from an act which had already taken effect, and that such relief did not fall within the ordinary scope of Order 39, Rules 1 and 2 CPC. Now the question therefore arises as to whether in such circumstances the plaintiff is to remain remediless, or whether the civil court may exercise its preserved inherent jurisdiction under Section 151 to meet a situation for which the CPC provides no specific interim mechanism. The answer is furnished by the principle laid down in Manohar Lal Chopra versus Rai Bahadur Rao, Raja Set Hiralal, my lord, as cited under paragraph 23 at page number 8 of the judgment number 6, my lord, of this corrected version, volume 1, my lord.
Yes.
My lord, page 94, my lord.
Yes.
Kindly come to page 101, my lord. Para 23 at the last, my lord. Page 101, para 23. Subsequently, the apex court in the case of Manohar Lal Chopra versus Rai Bahadur Rao, reported in AIR 1962 SC 527, after taking note of the divergent views by various high courts in the country, has held as under. There is a difference of opinion between the high courts on this point. One view is that a court cannot issue an order of temporary injunction if the circumstances do not fall within the provisions of Order 39 of the code. The other view is that a court can issue an interim injunction under circumstances which are not covered by Order 39 of the code. If the court is of the opinion that the interest of justice require the issue of such interim injunction, we are of the opinion, my lord, Supreme Court is of the opinion, my lord, we are of the opinion that the latter view is correct, and that the courts have inherent jurisdiction to issue temporary injunctions in circumstances which are not covered by the provisions of Order 39 Code of Civil Procedure. There is no such expression in Section 94 which expressly prohibits the issue of a temporary injunction in circumstances not covered by Order 39 or by any rules made under the code. Now, my lord, this same principle that is laid down in the Manohar Lal is also reflected.
Don't repeat. If the same principle, please don't repeat.
No, not same principle. A little bit means this on this.
For what proposition?
My lord, kindly come to judgment number 1, my lord, of this compilation corrected version.
Yes.
I just want to say, my lord, that this same principle of the Manohar Lal is reflected in the decision of the Allahabad High Court in Satya Prakash and another versus First Additional District Judge Eta and others. Now I'll read the judgment, my lord. Kindly come to page 20, my lord.
Yes.
My lord, para 14, my lord. Page 20, para 14 at the last, my lord. Last 5 lines. It is held. It is held that even if an application for temporary injunction under Order 39 Rules 1 and 2 CPC is rejected, even then the plaintiff can move fresh application under Section 151 CPC with a distinction that in case temporary injunction is granted under Order 39 Rules 1 and 2 CPC, then misappeal is maintainable under Order 43 Rule 1. But if an injunction is granted under Section 151 CPC, then no misappeal would be maintainable, only revision would be maintainable under Section 115. Why, my lord, this is 115? Because by that time, that amendment did not come for the Section 115, because this judgment was passed, my lord, on 13th of March 2002, and the amendment for Section 115 had been in effect from 1st of July 2002, my lord. And for that, I'll just cite one judgment, my lord, for just this amendment. I'll not read it out. Where's the time, my lord? That is the judgment number 2, my lord, on page 31. That is Rajeshwari versus Puran Indauria. That is just citing this amendment, madam. On page 40, my lord. Page 40. The ratio is given there, my lord.
Yes.
I'm not reading, my lord, this one. Okay. Next, my lord, kindly come to judgment number 3 of this corrected version, volume 1, my lord.
Yes.
Page 42, my lord. My lord, the ratio part is at page 69, my lord. My lord, para 6, my lord. The right of appeal is a statutory right and where the law provides. Now, let me cite the citation, my lord. This is the Radhesham and another versus Chabinath and others, this judgment, my lord. The right of appeal is a statutory right and where the law provides remedy by filing an appeal on limited grounds, the grounds of challenge cannot be enlarged by filing a petition under Articles 226 or 227. But in my case, my lord, I have already cited, mine is not coming under the appellate jurisdiction, my lord. The same thing is iterated in the bottom portion, my lord. Shall I read, my lord? Okay. Now, this principle laid down in Radhesham is also consistent with the earlier decision as was held by a coordinate bench of the Honorable Karnataka High Court in Viradabba versus Mayappa. This is the judgment, my lord, in 1B, just the judgment, the compilation today I have handed, my lord. 3A, judgment number 3A.
Yes. Yes.
Yes, my lord. My lord, page 11, my lord.
Yes.
Order 43, Rule 1 categorizes the various types of order. My lord, at the top, my lord, second line.
Yes.
Order 43, Rule 1 categorizes the various types of order.
So remedy is 151.
Yes, my lord. And also there is
Yes.
one more judgment, my lord. Just let me cite the judgment. That is, and also, my lord, this was the Karnataka High Court judgment. This was based on the Supreme Court judgment Keshara Dio Chamria, a very old judgment, my lord. And another judgment that is again that cited by the Honorable Rajasthan High Court. It is Ram Kumar versus State of Rajasthan, which is the judgment number 3B of this compilation, my lord.
Yes.
This ends my hearing for the my contention for the maintainability, my lord.
Yes.
Your application.
My lord, can we come to page 9 of his application?
9 of?
9 of the application,
application.
civil petition application. Page 9, paragraph 9. Before filing this civil revisional application, he also filed one civil revisional application challenging an order passed in 151 application that was dismissed by the trial court. And in this civil revisional application, Honorable Justice directed him to file miscellaneous appeal in connection with this order. But thereafter, he also
Against this order?
Against this order.
Where is that?
Order is not annexed by him.
My lord, I am.
Please wait, let him submit. Please take your seat. You have a chair behind you. Please take this.
And both the applications, the present application and the last application is same. Page 3.
No, this order is 27th of February 2025 is under challenge.
Yes, and because the last application against whom he challenged the preferred the civil application the 3997 of 203 is exactly the copy of this present application. And my lord, kindly come to paragraph 10 in page 9.
Page 9.
Page 9, paragraph 10. The petitioner states the subsequent.
So here it was directed that he has to file a miscellaneous appeal.
Miscellaneous appeal. But without preferring any miscellaneous appeal, he prepared another 151 application under CPC. And page 10, paragraph 10, the petitioner states that subsequently he preferred preferred to file a fresh injunction application under section 151 of the CPC in the trial court, that is on 28 March 2024, on the basis of valid ground of the urgency changed circumstances. So he clarifies his application as an injunction application, and might come to page 84 of his civil divisional application. What is the heading? He section 151 of the Code of Civil Procedure, praying for stay of the impugned order for dismissal from permanent service and other consequential interim relief, my lord. And in my opinion, my lord, this application is barred under order 20 under rule 20 sub rule 3 of the civil rules and order, because there are so many prayers in these applications.
Multiple prayers in one application. All right.
And all, because my lord, he is already, that the dismissal order has already taken place, and he prayed the relief in this application, which is the main relief. That is the prayer of the suit is such relief being no consequential relief, my lord.
Page
101, my lord.
Yes.
Because the relief claims in this is the main relief which he claims in his main application, main suit.
Yes.
And for the, I am relying upon one judgment already I handed over in earlier occasion, my lord. It is in reported in 2000 volume 1 CHN.
What is the cost title?
Cost title Ravi Misra versus Reliance Petroleum Limited.
Ravi Meheria.
Ravi Meheria. Relevance paragraph in paragraph 17, 18, 17 onwards. This, as mentioned earlier, although the second application was one under section 151 of the code, the prayer made therein clearly comes under the purview of order 39 rule 1 and 2 of the code. Thus, a fresh prayer for the petitioner for injunction was turned down by the order impugned. Therefore, rejection of such applications squarely comes under the purview of order 43 rule 1 R of the Code of Civil Procedure and was appealable. And if I accept the contention of Mr. Shah in the event that if a litigant instead for correctly describing an application as one under order 39 rule 1 and 2 of the code of the captions the same as one under 151 of the code, any order passed on such application on merit will be appealable simply because either the parties wrongly described to make it under 151 of the code pass such order without clarify its position.
Yes.
And litigants cannot be allowed to bypass the provisions of the code by wrongly describing an application as one under section 151 of the code, though it is really comes within the purview of order 39 rule 1 and 2, resulting in deprivation of right to appeal of the litigation. This is my conviction.
All right.
My lord, kindly come to page 9 again, my lord, of the CO application. Page 9, what he just cited.
Yes.
Para 9, my lord.
Yes.
Let me correct his submissions, contentions a little bit, my lord. The first application, injunction application that was filed under order 39 was disposed of on 30th November 2022. And that temporary injunction application was directed to be modified by the learned trial court on an earlier date in that same year, my lord. That order was dated 11/4. Come to the third line, my lord. 11/4/2022.
Yes.
Now, what I did, my lord, that modification, I challenged that modification. The order that is not annexed here. That is actually on the separate footing, my lord. Completely on a separate footing, because I had prayed for a recall under section 151. Those petitions was praying for recall of the order that was passed on that 11th of April 2022, and another 151 application for recall, the recalling of the order that is 30th November 2022. Now, Upon hearing the first recall application for the order dated the 11th April 2022, the learned trial court said this recall can't be done because on merits, even a subsequent injunction application has been heard and uncontested matter. Thereafter, I preferred a 227 CO application in this court in the year of.
That is CO 3997.
Exactly. That is on a completely different footing. And that time, my Justice Sampa Sarkar, Honorable Justice Sampa Sarkar, had not directed me, given me a legal liberty that if I want, I can file a misappeal, my lord. But that direction ends the matter there itself. And this is on a complete new application under Section 150 or not a recall, my lord. This is a injunction application.
All right.
And one more thing, just one more thing, my lord. The judgment he has cited, and the Shukhendu Maiti judgment. Kindly note the date of the judgments, my lord. And the judgments, the three Supreme Court authoritative judgments that I have cited, my lord, those are subsequent, my lord. All of the three. That is the Radhesham, the Sangeeta Singh, and that Roshan one, my lord.
Ashun, heard the petitioner in person.
For this
Written notes of submission filed by the petitioner appearing in person is taken on record. Yes, next.
Grateful to your lordship.
Yes.
Grateful, my lord.
Yes.
On the last direction, we were directed to serve on the mother, but the service is still incomplete, your lordship. However, we have mailed her also yesterday.
Why it is appearing under the hearing to be mentioned?
Your lordship, because this arises out of a failed mediation proceeding. The honorable court directed this matter to go for mediation, and the mediation subsequently failed. For fixing of this civil division.
Have you served?
Yes, your lordship.
When have you served?
Your lordship, I've served her on 20th of August, and also issued an email on 24th of August.
The learned advocate appearing for the petitioners.
Kindly fixes that date. I'll again intimate her lordship the kind.
Please intimate.
Your lordship, it's the third time, your lordship. We have served a third time. She already has the copy of the civil division. She attended the mediation proceeding.
She's appearing.
She's appearing in person, your lordship.
She's appearing in person.
On the last occasion, she was appearing in person. Your lordship, kindly indicate a date. I'll fix a date for hearing.
List this matter on.
Acting on behalf of the petitioner. The interim order will expire in the end of August, my lord.
The interim order is extended.
That has already been disposed of, my lord.
It has been submitted that can 1 of 20.
Lordship, I am for the opposite party.
Yes. Yes.
The DW was closed, Lordship. That is why I am here under Article 227, Lordship.
Lordship, kindly see the conduct of the petitioner. Lordship directed to serve on the 14th of April 2025, and he has served in the August 2026.
Is
Lordship,
it true?
Lordship,
Lordship,
Is
actually,
it true? Is
actually,
it true? Please say yes or no in one word. Yes or no.
yes, Lordship.
Then
and Lordship,
Lordship,
he has filed this application for extension of interim order in the month of January 2026.
yes.
But we are not.
kindly hear the matter, Lordship.
Why did you serve at such a belated stage?
Lordship,
It shows that you are interested in delaying the suit.
Lordship,
Yes.
Lordship, kindly,
Lordship, kindly see the order of your Lordship.
Yes.
Twenty-fifth April 2025, Lordship. Kindly see.
Yes. Who are you? You are the husband or the wife?
wife, Lordship.
Wife.
Yes. What is the next date fixed?
Tomorrow is the next date, Lordship.
That is why he served.
Tomorrow
And
is the date fixed.
Lordship.
So please appear for the evidence. I will allow you to lead evidence. Tomorrow, no further adjournment. If please take instructions, come back, then I will pass an order. Whether she is ready to face the talk tomorrow. Please take instructions,
Lordship,
then come back.
Lordship, 6 times the expected hearing.
Yes, yes. I will be taking over at 12. Please take instructions and come back. Yes.
I am for the petition.
Yes.
My substitution application rejected on the ground of delay of 1 day.
Your?
Substitution application
Yes.
rejected on the ground of delay of 1 day.
Rejected on the ground of?
1 day's delay. Thereafter, I
Who is
filed-
appealing for the other side?
No one has filed lokalatnama. I have checked the status.
The interim order is extended.
I am for the opposite party, number 1.
I am for the petitioner.
Yes.
The extension of interim order that is expiring this month, end of this month.
Yes.
But they have also filed an application for vacating. Impugned order rejects my order 7 rule 11. I am defendant in the suit and allows their order 6 rule 17.
Yes. The interim order. This is an application for extension.
My lord, the application can 1 that has been filed by me for vacating the interim order.
Can one
I appear for the petition.
I'm appealing for the opposite party.
Yes.
The interim order is till the end of this month, my lord.
What is the miscase for?
The suit for declaration injunction in which we have opted.
Injunction.
Yes. Injunction was
The-
been granted in the trial court.
Order of
The
status quo.
interim order is extended till the end.
Since both the petitioner and opposite party are septuagenarian, so my lord, it is my humble prayer. Can it?
The mention after the puja vacation. Consider. Yes. Next. Yes.
Arising out of the suit for declaration of tenancy right and recovery of possession under section 6 of the specific relief act. Lord, I have served, my lord. The interim order was there.
Section 6. How can you pay for a declaration of your
Declaration of my tenancy right, and Lord, thereafter, my lord, the eviction. My lord, I have been evicted.
Section 6 only if you are dispossessed, your possession can be restored within 6
What
months. Where is the question of that declaration and other things
Checkered
there?
history, checkered history was there, my lord. Lord, the
No, I'm asking you,
initial,
where is
my
the
lord,
scope? What happened on this?
Initially, my lord, before induction as a tenant, the interim order of injunction.
What is the
was
impugned
passed.
order? Who is appearing for the other side? Have you served?
Yes, served.
Who is
Immediate
appearing?
service was there, my lord, Vishwarup Acharya.
Mr. Bonik Lanet, advocate, appear.
For the petitioner, in respect of arbitral proceeding, my lord, an amendment order is under challenge. Main ground is, my lord, that whether the mandate has been expired because
The interim order is extended. Yes. What are these two applications?
extension of interim order, my lord.
These two are for extension of interim order.
Lordship, I'm for the opposite party. Lordship, may kindly take up the application for extension. Lordship will find Lordship's first order was on the 17th of September 2025. This is already almost September 2026. The interim order is there for almost 1 year and they are just extending it without taking
What
any
is the
steps.
impugned order? What is the impugned order?
Kindly see page 6. There shall be a stay of all further proceeding title appeal 71 of 2024 pending before learned judge Chief Brings City Civil Court at Calcutta.
Yes.
Page 6, my lord. Kindly see page 6 annexure A.
Page 6 of the
Annexure A of the extension application, my lord.
No. I'm asking you, what is the impugned order?
Impugned order is annexed, my lord. That's why I'm.
What is the nature of the
Oh,
impugned
never is a
order?
Stay, my lord. Stay. Stay.
What stay?
Stay of the further proceeding in title appeal 71 of 2020.
Why?
Because, my lord, they are during the pendency of the eviction suit, they issued second eviction notice during the pendency of the suit. Now, I showed judgment that during the pendency of the eviction suit, they cannot send second notice, but because
The moment they send second notice, the first suit will automatically become date.
Lordship, the petitioner is trying to misguide the court. Lordship, the application for eviction was on several grounds, including
Dismiss the appeal, title appeal.
Title appeal.
Lordship.
Title.
Lordship.
Please give me a minute.
Yes, sir.
The suit was dismissed.
Suit was initially, yes, suit was dismissed. Their suit was dismissed. Then, my lord, they preferred an appeal. Appeal is the continuation of the suit. And they issued second subsequent notice on 16th April 2025 during the pendency of the appeal.
Yes, where is your judgment on the second notice? Please show me.
Yes.
68
My lord,
Supreme Court.
No, my lord, I have already given the judgment. It is on probably on the record, my lord.
What is the decision? 68 Supreme Court.
No, my lord,
You have not brought 68 Supreme Court.
Right, in this judgment, it's clearly written, my lord. The moment they will send the second notice, the first notice will automatically become date. What are these? Kindly see para 13 at the very outset.
Para?
Para 31.3 at the very outset, although that is not.
There is no paragraph number
My lord,
here.
it has been downloaded from the official website, my lord.
Lordship, there must be another copy in my lord's file.
Yes, my lord, I have. My lord, give para 13, my lord, kindly see. My lord, kindly see that paragraph number is there. The question is, including the pendency of a suit for eviction, my lord, the landlord gives a face notice in terms of 13.6.
After hearing the learned advice,
The date, my lord.
after contested application after puja vacation, will appear. Yes.
Sir, I am for the petition.
Yes.
Sir, there is an interim order of stay of all further proceeding of the suit till end of this month, my lord.
What is the order which you are challenging?
My lord, by the order impugned, the learned court closed the evidence of DW by rejecting the prayer for adjournment. The date was
Who is for the other side? Have you served?
Aspect of service, none is appearing, my lord. Repeated service was there. I have filed 2 affidavit of service on last 2 questions also.
None appears to.
For the petition. But
the opposite
here,
party
you know, at the appellate stage, admittedly 23 years after the cause of action as pleaded, the instant amendment application is being filed at the appellate stage. Initially, suit for eviction dismissed because it was only on the ground of default.
Cannot be filed application for amendment. At the appellate
I cannot say, but that can be. But at the appellate stage, admittedly 23 years after the cause of action. Now
the amendment sought for.
Amendment sought
page
for
48.
kindly take
Page 48 is the schedule. Registered lease, suit filed on the ground of forfeiture. Suit dismissed. At the appellate stage, lease expired by flux of time. That part, I want to bring before the appellate court by way of an amendment.
In the interregnum period when the
please give me a minute.
The appeal is of 1997.
Mr. Mukherjee, if this fact of expiry of lease
in the year 2023, why I am coming?
No, the lease might have been of 83.
No, but according to him, the alleged lease expired in 1999.
96.
1999.
Sorry, July 1999.
Yes. And this appeal is 1997. The amendment application is 2023. And more interestingly, I shall show before your lordship, in the interregnum period, this appeal got abated. There was a application for Order 22 Rule 9. In that application, there is a specific cross-examination. There is a specific admission on the part of the landlord that I am the tenant and he is in possession through me. So this happened sometime in 2014 when the lease got expired according to him in 1999. So my right accrued according to 116.
Yes, so that might be.
But the learned judge has not gone into the entirety. Kindly see, he thought this is a subsequent event. But in 1999,
subsequent event
2023,
during the pendency of the appeal, that you cannot dispute.
No, I am not disputing that. But so what happened in the interregnum
after the passing of the decree?
That's why, what happened in the interregnum that we have argued, but the learned judge has not yet. He simply took that yes, it's an amendment, subsequent event, 1997 appeal, 1999, according to him, the cause of action arise. 2023, the instant amendment application is being filed. Something has to be gone into. It's not that in a cursory manner the learned judge has gone into that yes, it's subsequent when nobody will be prejudiced. There I am on. But a substantial delay in preferring an application, the court has to look into. It's not that 23 years after.
Yes, what do you
My
say?
lord, exactly, my lord, on a similar proposition of law, my lord, the Supreme Court has decided, my lord, once, my lord, application under Order 6, Rule 17 has been decided by the appellate court in its discretion, my lord, the court under, my lord, Article 227, my lord, cannot exercise it. My
After
lord, this
hearing
is,
the
my lord,
learned
the
advocates
similar
for the
point.
respect.
Interim order extended twice, my lord. I served also twice, my lord. First time notice, copies, then notice, my lord. And
None appears to oppose the prayer for.
This matter I am appearing on the opposite party.
The order the end of this month.
My lord, with regard to extension, I have strong objection because of the fact your lordship will find from their application. They have preferred this civil revision in respect against the order dated 38/2025, my lord.
30th of August 2025.
Yes, my lord. There is order in portion they have quoted over here, just omitted the amount and by which what time they have to pay the instrument. Nothing has been mentioned. Just concealing all this fact, they have obtained this stay order. My lord, your lordship will find this is the order. Just this is the ordering portion. From ordering portion, your lordship will find that there is so many conditions. And what they are writing,
No,
application petition taken up for hearing, order dated 38/2005, learned judge state the execution case pending hearing of the miscellaneous subject to.
From where are you reading?
From their application, page 4.
From their application?
From page 4, paragraph 8.
No, that is page 4, paragraph
8.
No, that might be, but the impugned order has been
Impugned
annexed.
order I have given, I have already given.
No, that has been annexed here also.
They have also, definitely they have annexed. But I have filed 7-2 order also because this matter appeared before the Honorable Justice Mr. Rai. At that time, he asked me to produce the 7-2 order. Today, I have brought that order. Now, as on this date, my lord, landlord will get 7 to 8 lakhs rupees.
Please give me a minute. The order dated 30th of August is under challenge.
Yes, my lord.
Yes, my lord, both the order
Give me a minute.
by the first.
Just ordering portion will speak. My lord, this petitioner appeared before this trial court in title suit. When it was declared that they are defaulted and has to pay 2,96,000, they disappeared.
But the order 9 rule 13 has to be disposed of.
No, my lord, that should be.
That time stay has to be continued.
My lord, that money has not been depositing because matter has been stayed by your lordship. My lord, your lordship has already.
That order, my lord, there was a
not even depositing month by month, and apart from that 7 to 2,90,000.
That is not being deposited. So you take out an application. I give you that liberty. Please take out an application. If it is found that these conditions are not being complied with, the stay will be vacated.
My lord, I am praying before this law. They are not complying the court.
My lord,
Sir, that has to be adjudicated. Yes. So I am giving you liberty to file an application before the learned executing court. If they fail to show that they have complied with, I give.
I am deeply obliged. I am deeply obliged.
Yes, Mr.
I am deeply obliged.
My lord, so far as the first order is, that was the order that there was a direction. Again, an order for recall was made. Both the orders.
Order 38 was stayed on the ground that order 9 rule 13 is but it was some conditions.
Yes. Yes.
So he says that the conditions have not been complied with.
My lord, we have, my lord, paid.
So
My lord, trial judge
I
already,
give him liberty to make an application after hearing both of you. The
my
court,
lord, my lord, trial judge already accepted that they have failed to comply the order. That's why stay order vacated. That order is there.
where is the stay?
My lord, I'm reading out that order. No, I'm reading out that order, my
Where
lord.
is that?
My lord, that order we have also challenged.
No, ঠিক আছে, বলতে দিন। একটু বলছেন তো।
Where is that order?
My lord, in the event, my lord, judgment which I have handed over right now, last portion,
What is the date of that order?
Order date 38th.
No, 30th of August I have seen.
30th August.
Yes. Where does it say that they have not complied with?
That's why I'm coming, my lord. In the event, last page.
Yes.
In the event of the failure of the judgment debtor to deposit installment of area occupation charges determined by this court by the order
Yes, so you
dated.
point out to the executing court, file an application that they have vacated, that they have not complied with.
That is already decided by trial court.
Where is that?
Here is charges amounting by the by
Sir, it
dotted
says
auto
in the event.
of the event occupation charge such TS number ato shall stand automatically vacated.
In the event they have not paid. So that requires an adjudication on that, whether they have complied with or not.
That I will mention to trial court. Yes.
This is what I am saying.
Yes, my lord. Yes, my lord.
With your lordship. Next. Call the next matter. Yes.
আমার এই কপিটা দিয়ে দেবেন অর্ডারটা আমার অর্ডারটা দিয়ে দেবেন আমাকে অর্ডার
I'm for the petitioner, defendant petitioner. So I use my application that I filed one application. I filed the suit for declaration. I got an order of injunction, absolute order. After 2 months, the opposite party, my brother, filed another suit. In that suit, my lord, here I filed one application of non-mutability and also written statement as filed.
As also
written statement.
Yes.
That application has not been fixed for hearing, and the learned court below fixed the entire matter on 19th October. Urgency is there.
19th of October.
November.
19th of November.
My lord.
Puja vacation is intervening, Mr. Das.
My lord,
What
19th, kindly see the
preponing, it's difficult if you from here, because I do not know I can direct that application to be taken up on that date itself.
without granting any
This application under Yes.
Lordship, the learned advocate appearing on behalf of the petitioner before the learned trial court, Lordship, is praying for only 3 days time, Lordship, to.
No. If tomorrow is the date, she has to appear on that ground, otherwise not. I will not interfere with
Lordship,
this.
cost imposed upon wife at least 5 times.
That is why I asked you to take
Tra-
instruction.
Tomorrow, Lordship. Fix tomorrow, Lordship, kindly.
Tomorrow is the date that you have ascertained. I'm allowing the evidence of the wife.
You are praying only for 3 days, Lordship.
23 we এটা 5
5 যেটা 512টার সময় রাখলাম 500 করে রাখলাম
we completed our evidence in 2023, Lordship. After 2 years passed, nothing was happened.
She's getting alimony. She's getting alimony.
No, she is an employee of railway. We both are employee of railway.
No, previously she also paid for time.
Yes, Lordship.
Where is that? Where are the other orders?
Lordship, that I don't have, but he has not annexed the order sheets.
You have the copies of the orders?
No, I have the dates, Lordship, but I don't have the orders.
Though this matter is appearing under Yes. None appears for the petitioner.
18 is my application. The petitioners are before my lord for expeditious hearing of the suit and also for.
What is the nature of the suit?
It is for eviction of a license. Now,
What is the stage of the suit?
my lord, an application it's for issue framing of issues.
Application for framing of issues.
For framing of issue, there is an application preferred by the petitioners dated 12th of October 2023 for arrear occupational charges that has been pending from 2023 onwards for occupational charges and also for the arrear occupational charges.
When that application was filed? When that application was filed?
October 23, my lord will kindly come to page 20 of this application. Now, the petitioners have already argued it. It's part heard. The defendant is not also filed and written objection. It's pending from October 2023. The next date is fixed on December 2026. Now, my lord, this
next date is fixed on
December 2026 for filing their objection and hearing. Because it has been already part heard, the petitioners have already argued the matter. And this petitioner number 1 is an octogenarian lady, and entire medical expenses used to run from this occupation, from this licensee fee that she used to get. Now, from 2020 July, admittedly, nothing is being paid, and they are enjoying a possession.
This application under Article 2. Yes. Next.
My lord, the petitioner is the petitioner wife during the pendency of her title suit against her husband invoked section 26 of the Domestic Violence Act and filed a miscellaneous case therein, praying for reliefs under 18 to 22 and also invoking 23, my lord. My lord, by the impugn order, my lord, comes to page, this is page 20, annexure A. The learned civil
Page
judge.
20.
Page 20, yes, my lord.
Yes.
By this impugn order, the learned civil judge dismissed my application for a section 23 at the ad interim stage, and by himself opened up a question of maintainability by invoking, my lord, Balram Yadav. I will come to Balram Yadav in a bit, my lord. My lord comes to the third paragraph onwards.
The interim relief has been rejected. It has been fixed. You have been directed
lord,
to
yes.
issue notice.
Yes, my lord.
Have you issued notice?
Yes, my lord.
What is the next date fixed?
My lord, however, the 2611, however, my lord, the question is that, my lord, comes to fixed here the fixed 27/7/2026 for appearance and hearing on the question of maintainability
Yes.
of the proceeding in the light of section 7, 8, and 20 of the Family Courts Act, and the pending matrimonial proceedings between the parties. My lord, the learned civil judge has invoked also Balram Yadav, which has absolutely no bearing to this because section 26 is a standalone
Only
provision.
an ad interim prayer was rejected. It has
And
been fixed.
maintainability and question has also been opened.
Yes, that will be decided after hearing both parties.
But my lord,
You can make your
I'm
submissions
my
there.
lord, I am aggrieved by that because maintainability.
Being here pending, it will be again delaying.
That's a very
So,
innocuous prayer, my lord.
no, ex parte that cannot be allowed.
My lord issues notice because this will be very
After issuing notice, madam, that will further delay. I can direct on the next day, the mentality and other points shall be taken up for hearing.
My lord, may I show one judgment? My lord, Supreme Court has held the statute is very clear.
Madam, I cannot allow this application ex parte. If you want, I can.
My lord, allow me to make just one submission in Carl Rafael Tadao. My lord, Balram Yadav is not even on this point. My lord, in
That I can make it clear that you can raise that point at the time of hearing.
my lord, very identical case. Karl Yadav, this was Bombay High Court, and this was with reference, there was a family, because all these cases, my lord, the parties aggrieved have gone from the family court, where the family court has entertained and allowed an application under 26. Now here, my lord, comes to
Where is your
paragraph 10.
application under section 23? Where is your application under section
My lord, I have not annexed application under application. My lord, I have not annexed it. I have a copy of it. Application.
Yes.
My lord, this is the copy. 26. My lord, this one is the 26 application, the one with the officer, my lord. My lord, sees the holding by the trial judge, by the civil judge, my lord. He has he has opened up a can of worm, the order, my lord, by resting his refusal on these considerations, which is absolutely extraneous to my to my petition under section 23, namely the pendency of the husband's matrimonial proceedings.
By the order impugned.
What I appear for the petition. The
Yes.
defendant in an eviction suit is the petitioner before your lordship.
My lord, the summons were served on 4th of December 2024. I filed an application under section 7.1 and 7.2 on 9th of December 2024. So within 30 days. In the 7.1 application, I state that there is no default, and I thereafter, my lord, went on depositing, my lord, rent every month. When the 7.2 application was taken for hearing, it has been held that I have admitted that there is default, but I have not deposited the rent. Accordingly, the 7.2.
Where is your application under section 7?
My lord, at 7.1 is at page number 14.
7.1 is
Page number 14. Worship will find paragraph 5. That this defendant has no dues pending of rent for the tenanted premises, as has been alleged by the plaintiff of the suit, that the plaintiffs have paid rent till July 2024 through agent of the plaintiff, through whom this defendant used to pay rent very often. That since thereafter the plaintiff used to collect rent from the defendant of the suit in cash without issuing any rent receipt in the name and favor of the defendant. The defendant wants to continue with the deposit of the rent in the name of the favor of the plaintiff landlord, so that the plaintiff landlord may not allege the defendant for non-payment of rent. And my lord, in the 7.2 application at page number 16.
So you have paid rent till July 2024.
My lord, I have in the next paragraph, my lord, kindly takes a page number, paragraph 7. I have stated that since thereafter the plaintiff used to collect rent from the defendant of the suit in cash without issuing any rent receipt. So it is since thereafter means after July 2024. Till the date of filing of the application, because in paragraph 5 I have said that there is no dues pending.
What is the remedy under the West Bengal Premises Tenancy Act if no receipt is issued?
Well, that has to be decided under section 7.
What decided? Statutory? Have you have not made out any case for that?
My lord,
this is as vague as that.
Under 7.1, my lord, I have in 7.2 I have stated that there has to be an adjudication. So there has to be an adjudication that I am a defaulter.
Yes, have admitted. There is no document for you to show, prove that you have paid this.
But admitted cases, my lord. But I have.
You have taken that risk, Mr. Chatterjee.
But admitted case is that I have made deposits. My lord, I have paid. So the adjudication has to be done under section 7.2. Thereafter, my lord, the question.
Show me your application under section 7.2.
My lord, kindly takes up page 16. Lord, kindly takes up page 16. It's wrongly.
Starts from paragraph 9. It should be paragraph 1. It should be paragraph 1.
Wrongly, my lord. Paragraph 13.
Yes.
The defendants have no dues pending of rent for the tenanted premises, as have been alleged by the plaintiff of the suit. And if any due is pending and found by the court, then the defendant is ready to pay the said amount as will be determined by the court. But my humble submission is that if there is any default, that has to be adjudicated under section 7.2. It cannot be said that 7.1 has not been complied with, because I have stated there is no due, and thereafter I am depositing rent every month. And my lord, 7.3 has been invoked and it has been struck off. Defense has been struck off.
When the suit was filed? Where is the plaint?
The plaint is at page number 10.
Mr. Chatterjee, the notice to quit is dated July 2024. And you mean to say thereafter the plaintiff accepted the rent?
This can be, my lord. It can come into the mind. It may come in my mind also.
May,
but the thing
if
is
you
that
take a frivolous plea,
it has to be adjudicated.
Can be adjudicated here and now. From your statements in 7.2.
The adjudication.
From your statements in 7.2.
Adjudication in 7.1. What has been done, my lord, in the impugned order is that it said the 7.1 has not been complied. Accordingly, I resort to 7.
Yes, because please see your statement in paragraph 7.2. It has been said that you have paid rent till July 2024.
My lord, here I have said 7.2.
Paragraph 14.
That though the plaintiff have paid rent till 2024 and not in 7.1, my lord, I have stated that I have already
contradictory. So 7-2,
Has to be an
7-2
adjudication under
also.
7-2.
Even if I accept your submission 7-1, there was no default. But 7-2, there is an admission, there is a default, and you are obliged to pay the deposit the entire admitted amount along with
But in
7-2.
7-1, my lord, I have stated that there is no dues, and my lord, at this stage, my lord, without adjudication of 7-2, my lord,
7-2, you have not said. Please see paragraph 14. Then paragraph 15 is a different thing. This is not the same language as in 7-1.
correct. But see, paragraph 15,
Yes.
that as a plaintiff used to collect rent from
Yes,
the
this
defendant
refers to what?
in cash
This is
without
in general. That is in general. Because what is the allegation in the plaint? From which date?
Both application which taken harmonious construction, my lord, kindly takes up both applications
This-
together, and adjudication requires under 7-2.
No adjudication.
My lord, kindly, my
No
lord.
adjudication is necessary.
My lord, because in 7-1, I have
See, paragraph 3, have not paid rent regularly to the plaintiff in spite of continuous requests since September 2022. So specific allegation is you are a defaulter since September 2022. You have said, yes, I have paid hand to hand till July. But from July, notice to quit is dated July 2024. After that, acceptance of rent, notice to quit goes.
my lord, that is the
When have you received the notice to
my lord,
quit?
that out.
When have you received the notice to quit?
I do not have the documents here. Do not have it here.
You do not have any document.
But presently, I am not having it here. I should kindly accept, can actually appreciate that if I am able to prove that he has taken the rent after my lord notice to quit, then that will be in my favor in the suit, in the trial.
What?
If I am able to prove that he has taken rent from me after he has allegedly he has served the notice to quit. My lord, that will be, my lord, in favor of my lord. That's a ground against my lord, defense ground against against the plaintiff. So, my lord, that cannot be decided at this stage without 7-2 being taken up.
Asu.
Paragraph 32 to 34.
Paragraph
32 to 34. In the application under 7-1 of the 1997 Act, the petitioner claims
Yes,
that
there was no admission in that fact, in that case.
here also, my lord, there is no admission. And one more. One
Mr.
more.
Chatterjee, Lord
22, I am for the petitioner. I am seeking for a fortnight accommodation. The advocate, the council engaged in this matter, has been suffering illness. He has been there's a surgery which has been.
By the order.
Twenty-three, my lord, I am for the petitioner, my lord. This application is regarding the expeditious disposal, my lord. Expeditious disposal.
Of what?
Of title suit 39 of 2020, 2004, my lord, which is renumbered as 4304 of 2014, my lord.
What is the stage of the suit?
My lord, this is in the stage of pre-evidence, my lord.
This application under Article 2.
Expeditious hearing to
Of what?
Well, the suit formula declaration of title, well, filed in 2023. Well, the stage, well, the framing of identity injunction, the next date of 23rd March 2027. Well, 2nd March 2027.
This application under Article. You are the plaintiff.
Well, I am the plaintiff.
This
Rule 11 application, your lordship, has been rejected. Your lordship.
What is the suit for?
Suit for simpliciter for injunction.
Where is the plaint?
Yes, your lordship. Kindly take, your lordship, page 30. Page 30, your lordship, starts from page 31. One
give me
page
a minute.
plaint.
Please
Yes,
give me a minute.
yes, yes.
Yes.
So my first attack on the plaintiff, simpliciter suit for injunction, lordship, is not maintainable. The reason is he has admitted in the plaint that his father was not a Borgadar. He has not
Was
been
not a Borgadar.
He was not declared as a Borgadar. He is saying his father was a Borgadar by operation of law. The moment you say so, lordship, civil court cannot give a declaration. You know very well that a simpliciter suit for declaration and permanent injunction is not maintainable. So you couch the suit in such a fashion that if I...
No, the father was a Borgadar by operation of law.
By operation of law.
Yes.
Your lordship, there is no declaration.
Maybe.
And moreover, your lordship, is application for Borgadar, your lordship, my instruction is dismissed.
Is?
Lordship, kindly take paragraph 3 once.
Yes.
That's excellent. Dhruva Pradok during such time had personal correspondence with Hemendranath regarding the bhag produced in the suit property by post. Apart from Dhruva Pradok himself filed an application on dated 17th of July 2014, should be 1014, to Bagnan BLLRO for recording his name as Borgadar in the suit property. But due to want of follow-up process for the death of Dhruva Pradok, the process could not reach its destination. So therefore, your lordship, my humble
Unless a
submission,
person's name is recorded in the record of rights, he cannot be a Borgadar.
there is no declaration.
What declaration?
It has to be, your lordship, declared by the competent
Recording
authority.
is something more that can be decided, that the civil court cannot decide on.
Yes, that's exactly my point. If the
Yes.
civil court cannot
But
decide,
the injunction suit by it will not be maintainable.
kindly, your lordship, may I say it is a well-settled principle where there is a complex question of law on facts. Your lordship, simpliciter suit for permanent injunction is not maintainable unless you ask for a declaration of title.
Sir, here he does not pray for declaration of title. Please consider this. He claims that his father was the Borgadar. Under the Subhola Bala Chattopadhyay.
Yes.
Thereafter Subhola Bala Chattopadhyay died. So his father, it is escaped that his father was the Borgadar under such and such.
Lordship.
Now the proceedings for Borga recording and another things that pending did not reach its destination. That is the other thing. But that he was cultivating as a Borgadar, that's the specific stand.
Yes.
So he's not claiming title in the property.
No.
He's only saying that as a Borgadar, I'm cultivating, and thereafter there is a dispute, there is an obstruction, there is a attempt to change the nature and character of the suit property.
Lordship.
Under such circumstances,
Lordship.
there is no cloud over the title. He's not questioning the title of the Subhola or our heirs or the subsequent transferees.
Lordship.
Why he will seek that suit declaration of title?
Lordship.
He's not claiming title.
Lordship.
He wants that as a Borgadar, I have to continue my right to cultivate.
Lordship.
That's exactly why he has paid for a temporary injunction,
Yes.
permanent injunction.
Lordship, we have to take, your lordship, the statements made in plaint and is true and correct. I'm taking it. Now, a suit for injunction can only be filed, your lordship, if he is a Borgadar on record.
Where is that? Unless he is a Borgadar, his name is recorded in the record of rights, he cannot file a suit for permanent injunction. Please show me. That's not a law, sir. This is to be referred to under section 21(3).
I'm grateful.
So that's the stage subsequent.
Yes, your lordship, till that stage is crossed.
So
Your lordship, can he file a suit for injunction?
Yes, yes, yes. That is why 21(3).
Lordship,
We
kindly.
see 21(3).
Yes, yes, your lordship.
So in a suit, it will be referred. It's not that after that suit has to be filed.
Lordship,
Then there would be no necessity for reference.
but if your lordship, if the declaration, your decision, your lordship, is not done till that date, your lordship,
Sir,
can I
that's
claim
not
it?
the law. If that is a dispute, he is claiming,
Yes.
I'm a Borgadar.
Yes.
If you dispute, if you have to dispute first, then it is to be referred. That's the law. You see 21(3).
21(3) and 4 both.
Yes. If any question
Yes.
as to whether a person is or is not a Borgadar arises in course of any suit, case, appeal, or other proceedings before any civil or criminal court, the court shall refer it to the officer or authority under subsection 1 of section 18 for decision, and such court shall dispose of the suit, case, appeal, or other proceedings in accordance with the decision communicated to it to the by the officer to whom the question was referred. So only that question will be referred. Suit will be kept pending. It's not that the suit will be dismissed
No,
or after that decision comes, suit has to be instituted. That's not the law.
But Your Lordship,
Well settled, sir.
I have seen Your Lordship, but the civil court cannot decide it. I understand Your
That is
Lordship.
why he has not. That is why he has not sought for a declaration that is a borgadar. That cannot be done. He says, "I am a borgadar."
Lordship.
If you dispute, then a question arises. That question will be referred to. So you make out that case, file your written statement. Yes, he is not a borgadar. Then that issue will be framed. That will be referred to. Suit will be kept pending. When the decision comes, on the basis of that, it will be decided. That's 21(3).
If his name is not in the record also, Lordship, can
The recording does not create, neither creates title, nor does it extinguish the right.
Kindly, Your Lordship, take this judgment, because my main hit, Your Lordship, is if you don't ask for a declaration, you'll simply sit a
Sir,
suit
here the question of declaration is not necessary because he does not want declaration of his title. He cannot also pay for a declaration of borgadar right in a civil suit.
So that's my, Your Lordship, the point of demurrer, Your Lordship.
The point of demurrer, if he has taken that point, then it would be a very good ground under Order 711. Cleverly, he has not paid for. He could not have paid for.
Certainly, if he has asked for, the suit itself is dismissed.
Sir, pure
Your Lordship, kindly cease.
simpliciter suit for injunction is also maintainable.
No, Your Lordship, kindly cease, Your Lordship, this judgment once.
In no case, permanent injunction suit is maintainable.
No, Your Lordship,
What are you saying?
Wherever, Lordship, may I just try
That there is no cloud over title. Sir, if there is a cloud over title, yes, declaration has to be sought for. In his plaint, he has not prayed for that there is a cloud with regard to the title. That is what you are not disputing. He is also not saying that, yes, there is a dispute between my and you as a borgadar. That also he has not claimed.
Lordship, paragraph 3 and 4, I'm just praying, Your Lordship, kindly look. And if Your Lordship is of the view that no, Your Lordship, create title is there, because my reading, Your Lordship, paragraph 3 and 4, Your Lordship,
Yes.
there is a dispute, Your Lordship, in connection with, Your Lordship, whether he's a borgadar or not.
Sir, when the dispute arises.
His averment, Your Lordship.
Sir, when the dispute arises.
The dispute arises, somebody is, Your Lordship, disputing it.
Yes. So that will come. Then the issue has to be framed. So that stage will be once you file a written statement. Prior to that, where is the question of that issue being raised?
Your Lordship, paragraph
That
3
stage
is-
has not yet arisen. You file your written statement, take that plea, then I issue question. That issue will be framed. That will be referred to before the revenue authority. That stage has not come.
Lordship, kindly sees this judgment, and if Your Lordship is not convinced, then I will not press it.
Yes.
You kindly take paragraph 12 once.
This paragraph.
Para 12, Your Lordship. That's why he has impleaded, Your Lordship, defendant number 8 and 9. Your Lordship, kindly sees.
The state authorities has impleaded. Otherwise, Your Lordship, there is no question of Your Lordship impleading Your Lordship the BLLRO and DLLRO. Page number 13, 30, defendant number 8 and 9.
This application under Article 2 Yes. None appears for the petitioner. Yeah, is that the instance of the plaintiff praying for a direction upon the learned civil judge junior division first court at Alipur to dispose of title suit number 2144 of 2024 expeditiously. To start from the order she is appended to the yes, Mr. Order.
For a direction upon the learned third additional, this sixth additional.
What is the order and the challenge?
Well,
Expeditious hearing.
Yeah, fixing.
What are the applications which are pending?
Well, yes, application is pending, two applications, Malad. One is 28.
What is the nature of those applications?
Malad, eviction degree was passed. The opposite party preferred appeal, Malad. Appeal was.
Who are you?
I am the landlord.
Yes.
Landlord plaintiff.
Yes.
Appeal was admitted at the time of admission, my lord. Stay of all further proceedings of the suit was stayed by the landed additional district judge and also directed the opposite party to pay a sum of rupees 8,000 per month as
Occupation charges. Yes.
And if the opposite party failed to deposit 2 consecutive months, the stay automatically vacated, my lord.
Yes.
It will be vacated.
Yes.
This is the order, my lord. My lord, they did not deposit, my lord, any amount, my lord. I filed an application on 20th May 2025. They failed to deposit the occupation charges as per direction of the Honorable Court. That was pending, my lord. 2000.
And what is the application dated 18th of February 2026?
18th of well, I filed another application. Stay should be vacated, my lord.
This application under Article 227 of the Constitution Yes, Mr. Banerjee.
My lord, 7-3 application allowed.
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 What remains, Mr. Banerjee?
My lord,
What
allowed,
remains?
allowed by a court who, my lord, did not have the jurisdiction, my lord, on the face of it.
Who did not have the jurisdiction to?
To, my lord, even receive the plaint.
To receive the
plaint and to entertain the suit. I tell you, Lordship, my lord, why? Borrowers are property, admittedly, my lord, for commercial purpose. My lord, even a suit for eviction from a commercial property, my lord, would fall under, my lord, the jurisdiction of the commercial court. And so, my lord, he could not have had, my lord, exercise jurisdiction. That's,
did you
my lord,
take
number
that
one.
plea in the
Ground
application
taken.
under section
My lord,
7?
it is a law point. This my lord, not urged, but my lord, when the revisional application came to me, my lord, I found that this is, my lord, absolutely, my lord, in conflict with the Honorable Division Bench judgment passed by my lord Justice Sabyasachi Bhattacharya in a matter saying that even if this is a suit for eviction of a premises tenant and the property is being used, my lord, for, my lord, commercial purpose exclusively, my lord, applying, my lord, 2(1)(c) of, my lord, the Commercial Courts Act, my lord, this is essentially a commercial dispute. The valuation of the suit would be not in terms of the West Bengal Court Fees Act, but in terms of section 12 of, my lord, the Commercial Courts Act. And, my lord, this court would not be having
This is
jurisdiction.
a
Two office
tenancy for a
spaces.
commercial purpose.
Yes, admitted. My lord, I can show it from the plaint.
My lord, the facts are very different.
May I?
And I'll indicate that, my lord.
May I?
This point is not at all taken. This is
Correct.
never taken, and this can't be taken. I'll also indicate that.
Can't be taken.
I'll
My point
indicate that.
can't be taken
So,
in the
Mr. Banerjee, you have a very good case at the execution stage.
No. My lord, I tell your
Yes.
lordship, my lord, what?
Decree is nullity. Let them take a degree.
Any collateral proceeding, even if I do not take this point, in any collateral proceeding, my lord, I can
Why
ask
are you
this
taking
point.
that at the earliest opportunity? You have a,
My
you
lord,
can
if it
take
is
that
on-
at the
My
execution
lord,
stage,
if it is
Mr.
on
Banerjee.
subject matter jurisdiction, then my lord, if this is, my lord, an order without
Is
subject
there
matter
a
jurisdiction,
different view taken by another bench of this court
my lord, I will,
to that which you have submitted?
my lord, I will place reliance, my lord, on the decision of the Honorable Division Bench, which has very recently come. That's, my lord, number one.
Decided over by Justice?
Sabyasachi Bhattacharya.
Thereafter,
My lord, that, my
there
lord,
is another decision taking a
Lord, I am-
contrary view.
bench.
Lord, I am told, Lord, I have not gone through by Justice Bosher. Lord, I have not gone through. Let me then, Lord, go through and come back. Let me then go through and come back. Lord, this is out and out, Lord, a commercial suit. Out and out.
Can't be, my lord. I'll indicate why.
Very well.
Let my learned friend, my lord, submit.
Lord, may I, Lord, exhaust my breath first, then.
The point is, my lord, they
Please give
filed
me
a
a minute.
section
Please
5.
Lord, if
Please
he
give
wants
me
to
a minute.
hijack me, my lord, he can. My lord, I will take my
It's
case.
very different, my lord.
I'm
Limitation
sure
Act,
we are holding
section
the
5
same
and
brief.
7.2.
We are holding the
That's
same
the
brief,
brief at
so
least I'm holding.
facts can't be different. I'm not on section 5. I'm not on section
That's what the
7.
matter is, my lord.
I'm sorry, my lord.
That's
My
where the
lord is
grounds are.
sitting in supervisory jurisdiction. Can look into every aspect of the matter. Can understand my learned friend is trying to, my lord, restrict.
I'm not trying to restrict anything, my lord. It's just that
Constitutional,
these
my lord,
arguments are
jurisdiction.
clearly beyond the pleadings. Never.
You filed your written statement, Mr. Banerjee.
Yes, they
Please
have.
show me your written statement.
No pointing. I'm very grateful, my lord.
Mr. Bagh, allow him to make his
My lord.
submission. He is the
Actually, I'm taken
petitioner.
aback because these points were never, my lord,
Lord, I have
highlighted
grown
any
old, my
stage,
lord. I do
any
not
stage
have
in the
that much of,
proceeding.
my lord, enthusiasm like Mr. Bagh has. My lord, my written statement is at page 35.
Yes.
My lord, first sentence covers everything. I don't need to plead, my lord, anything more than that in a written statement. I say, my lord, the suit is, my lord, not maintainable in law. I need not, my lord, plead anything more in my written statement. I have said this is not maintainable in law. That's
Please
number
show me the plaint.
plaint is, my lord, at page 15. Kindly, my lord, turn to page 18 once, then I will take your lordship, my lord, from the beginning of the plaint. Kindly turn to page 18, paragraph 9 once. That's his case in the plaint. First sentence.
Where is the judgment? Mr. Bagh, do you have the other judgment?
not immediately, my lord, because I did not know that my learned senior friend will take this point, because this point was never urged, not pleaded, beyond the pleadings.
That, my lord, I
Beyond
say
the
something
pleadings.
which is not there on record.
My learned senior always takes me by surprise.
So we can come back tomorrow, my lord. I am also not having, my lord, a
Yes, we can come back tomorrow.
hard copy.
And I'll come back with the most recent judgment, my lord, which will.
Either I win or, my lord, I get enlightened. So, my lord, I'm benefited for this.
Tenancy matter will be a commercial dispute, Mr. Banerjee.
Yes.
Please show me the judgment.
My lord, I have a soft copy as of now. May hand up the soft copy.
But perhaps I know which judgment is this, because I was at the risk, my lord. This traveled from, my lord, Alipur Commercial Court, and the point is now changed, my lord, thereafter.
Which
now it is, my lord, that it's not a commercial dispute.
Short kore bar kar. May kindly allow me a moment. It's just taking time to get download.
Pure tenancy can't be a commercial dispute.
What is the rate of rent?
350.
390 rupees per month.
390. But, my lord,
So section 12, my learned friends.
Let him, my lord, exhaust himself first. My lord,
Then I will not stop. That's the problem. I'll get too lazy
According
to stop.
to him, he has the best case. So that is not allowing you to make submission.
let him, my lord, make his submissions first.
Give me the decision.
My lord, I also need to go through this once. কিচ্ছু বলবো না।
You have not gone through that judgment.
My lord, cursory. My lord, I was briefed, my lord, 15 minutes back. No, I was briefed 15 minutes back. ফোন কি এখন বসে বসে স্যার খুঁজছিলাম। ঠিক আছে, একবার দেখি। কিচ্ছু বলবো না তোকে, তুই আমায় বলতেই দিবি না, আমি তোকে সব বলে দেবো। যখনই পাবি তুই আমার গলা টিপে ধরবি। Can you allow me, Milord, to come back tomorrow? Tomorrow or Monday, Milord, whichever is come. And Milord, I have a second point which is even better.
What is the second point?
That, Milord, the landlord-tenant relationship is not, Milord, yet decided.
Is not
yet decided.
That's why they've been paying rent, my lord.
According to you, there is no relationship of landlord and tenant.
From the written statement, Milord, I get so.
While admitting that they are paying rent to us.
Milord, if my learned friend is on admission, Milord, I was inviting him to that.
Yes, I understand, because they'll come to another point where there's a concession
That
by
will
us.
give rise, Milord, to a third point. Can you allow us, Milord, to come back on Monday? Milord, interesting case. Milord, if a provision of statute is draconian, has to be, Milord, interpreted in a way, Milord, that helps me out.
Seventh day Adventist perhaps settles the point, Milord.
Yes, Banerjee,
Seventh day Adventist, Milord, I have gone through.
the tenancy is governed under a statute.
Overridden by
The
Commercial
statute
Courts Act.
creates a forum.
Civil forum. Small Causes Court Act going by Bengal Agra Assam Act, Milord, is a civil court. Milord, I was, Milord, anticipating
Civil judge,
this.
it says, civil judge
Small Causes
having
Court
jurisdiction,
is, Milord, a civil
that's the
court.
language used.
Milord, Small Causes Court is a civil court.
Civil judge exercising jurisdiction, that's the language used. So now, and the how
Milord,
those that
Small
type of
Causes
suit
Courts are not, Milord, persona
to be
designata.
valued.
They are civil judges. Comes within, Milord, the High Court notification even.
And those are also the grounds which is to be.
Milord, learned judges of Small Causes Court get transferred to civil courts. Milord, come from civil courts.
Because this type of suits, the valuation depends upon the nature of the suit. This type of suits under the Suit Valuations Act and the Court Fees Act, how it is to be valued, that has been stated.
Given the honorable bench I have today, Milord, to argue this point, Milord, I would love to argue this point. Can you allow me to come back?
So, because section 6
yes,
uses
Milord, I
the
was
expression.
anticipating that from your lordship. Milord, having some experience, Milord, to appear with your lordship against your lordship. Milord, I was anticipating that. Milord, I have gone through Bengal Agra Assam Act. It
It
covers.
says
Milord,
civil judge
yes,
having jurisdiction
yes.
in favor of the landlord and against the
Small
tenant.
causes courts are, Milord, court
And
planet civil judges.
more so, the exemptions from the provisions of this act are contained in section 3.
Correct.
So if you do not fall within those
That is, Milord, with
exemptions,
regard to,
it cannot bring
no,
it
Milord, that is
outside
with
the
regard
ambit
to
of the Premises
that
Tenancy Act.
exemption is with regard to the status of the tenant, not with regard to, Milord, the status of the court.
Within the purview of the act also.
Milord,
So
I
if
come
you
back.
value it more than 30 lakhs or so, what is the
He has
threshold?
valued it wrongly. It's not me.
60,
30 lakh.
30, 30 lakhs or so. So
All of us
according
are,
to
Milord,
you,
two shop
this
rooms
has to
would
be
be
valued
30
at
crore.
30 lakhs. It's difficult.
The two shop rooms at Bara Bazar would be 30 crore. Milord, there can't be
No.
any
That's
second
not the
opinion with
that's
regard
not the
to that.
valuation
390
in
rupees
that.
per month.
Mr. Banerjee, that would come after the decree is passed. He will come up with a valuation saying this should be the occupation
It is
charge.
the subject
You will be
matter
saying,
jurisdiction.
no,
the
I
learned court
was
does
at.
not have. Milord, I have never come across a case before your lordship where, Milord, I did not face an initial hurdle. So, Milord, I know there is a hurdle. Milord, I am sure, Milord, I'll overcome that. Milord, I'll come back on Monday. Kindly allow me to come back on Monday. It is a plagiarism.
By the order impugned, the
Hence, it's a bad consent. That is what, Milord, in the 7-3 order, the Honorable Court, the Learned Court has held this. That I can't consider this, it's a wrong point, and hence 7-3 is allowed because whatever, Milord, transpired thereafter is bad in law.
Milord,
I'll show that from the 7-3 order.
I hope, Milord,
And that is what the point is. Section 5, whether it can be, Milord, filed in
All
this
right.
proceeding.
match the
by
pitch
the
of his Sunday আমি আসতে রাজি আছি।
না মানডে তুমি যদি উপরে দিকে Tuesday and not there.
তাহলে Tuesday।
to 60,000 minor on
আমি
by
কোনটা
26.
সুযোগ পাবো?
26 was 100. But from Monday, minor, I am trying to deposit the money, but there was a strike by the staff, therefore they have not taken. Today, minor, when I tendered the amount.
other side was there.
No, expert. But minor, the order has not been uploaded, therefore they are not taking.
এটা দেখে নিন
But pardon me
Does it
for
matter
pardon me for mentioning item 98 again. We mentioned in the morning.
Yes.
My lord, if it is permissible to if it is possible
I'm for the petitioner.
for today or maybe in the pre-lunch session tomorrow.
Order, my lord, which was passed. My lord, will recall, my lord, they had directed, my lord, all the directors to be present. Ex-party order personally. On 3rd September. My lord, on
There's a very small point involved.
151 application without any service to us on the first day.
Yes, what is the date on which the directors were asked?
3rd September.
3rd September.
3rd September.
My lord, kindly take it. Morning.
Well, if it is possible today, otherwise tomorrow pre-lunch session.
Today, my lord, I don't have any problem.
Tomorrow 3 p.m.
Tomorrow.
Well, it is possible to have it in pre-lunch session.
3 p.m.
My lord, can it be, my lord, earlier?
Pre-lunch session.
Matter, my lord, fixed, my lord, before.
And my lord, I have to. My difficulty is that I have to go back to Delhi and Raksha Bandhan tomorrow. If it could be done a pre-lunch session. If
Well, I don't think it will take, my lord, more than 10-15 minutes, my lord. In the morning, my lord, if you could come and tomorrow, my lord,
Because today first is the original side, thereafter certain fixed matters.
tomorrow morning,
tomorrow
my lord,
10:30.
Tomorrow morning, first half.
tomorrow morning, my lord.
Take 10 minutes. কালকে একটা 10 করে দিন 110
Very well.
90
Ek 10.
110.
110. So you can take the 4 o'clock.
Very good.
Great. Great.
Sir,
Plan.
please give the yes
Item 98.
item 90 চলো
Great.
I beg to pay for the petitioner. My lord, in terms of the last order, my lord is directed to issue notice under Rule 24 of the election petition rule. My lord must be having a report from the registrar.
Put case. With regard to respondent number 6 and 7, it returned with the endorsement insufficient. 6 is addressee absent. 7 is insufficient address. 7 address is insufficient. What is the address which you have
My lord,
given?
it is village Milki Danga, post office BK Chungri, PS Margram, Birbhum 731202. This is the address produced by the respondent number 7 in the affidavit filed before the election returning officer, my lord. You have derived all the addresses from the affidavits filed before the returning officer.
Where are the other respondents? It has been delivered.
It is appearing today, madam. The returned candidate is item respondent number 1 is the returned candidate.
Yes, one who was 6 and 7.
And they are the participants, madam. They were also participated
The
in
other
other participants.
so may not be that much relevant. As per the number of votes, who was the second? The petitioner.
Second. Petitioner was
Petitioner was the second. Yes, who appears for the Chief Election Commissioner, Returning Officer?
My lord, I have to inquire that. My lord, Chief Election Commissioner, my lord, West Bengal, Miss Anamika Pandey appears, my lord, CEO West Bengal, but I don't know she has been appointed or not. I have to, my lord, come back before your lordship with that information.
So I'm keeping it in the next week.
My lord, kindly.
In the yes. Yes, already.
Your Lordship's direction, it has been, notice was served, Lordship, and it was delivered on 24th of August, Lordship.
Yes.
What happened, Lordship? The decree holder, Lordship, filed a suit for eviction, Lordship. If Lordship kindly comes to Lordship, page 15.
Who are you?
I am the Lordship judgment debtor, Lordship. Without impleading me as a party, the decree was obtained. And Lordship, during Lordship, the
Without impleading you a party.
yes, Lordship, kindly comes to Lordship, page 15 of the
So then you are a third party.
I am a third party.
Why are you saying judgment debtor?
I, Lordship, filed an application under Order 21, Rule 97. In connection with that, Lordship, I filed a stay application. On the date of hearing fixed for stay application, the miss case was dismissed without going into the merit. Now, Lordship, challenging that, I filed a revisional application. Revisional application was dismissed, Lordship, by granting liberty the petitioner to Lordship approach before the appropriate forum, that is the miss appeal. I prefer a miss appeal as there was some delay. Though I, Lordship, plead before the learned appellate court that the learned executing court has fixed the matter on 28th of Lordship, kindly comes to the order, Lordship. Impugned order, last second page, Lordship, at the last paragraph, that learned trial court had fixed the Lordship on 28th of August in respect of Lordship, the execution of the decree, Lordship. The learned appellate court.
28th of July.
No, Lordship, it is, Lordship, just tomorrow. Tomorrow is the date, 28th of August.
No. Second page you are saying in the order passed in miscellaneous appeal, order dated.
It was fixed for Lordship 22nd for Lordship issue notice in terms of Lordship 21 Rule 22 1B. Now before that, Lordship, police help already allowed Lordship 208 application, Lordship, was allowed in favor of the Lordship decree holder. Now, Lordship, the learned appellate court, in spite of holding that there is a urgency, Lordship, does directed to serve and refuse the stay application at this stage.
The appeal was filed with a 412 days delay.
As Lordship,
Why?
It was, Lordship, pending before this Honorable High Court, Lordship.
What pending before this Honorable High Court?
The Lordship kindly comes to Lordship the order passed by the miss in the miss case at page 26, Lordship.
Have you served?
Yes, Lordship. I served the on 24th of Lordship August. It was delivered.
When it is the date before the executing court?
Tomorrow, Lordship. And learned appellate court, Lordship, sent the matter on November 19 for SRAD.
You have.
There is some urgency, Lordship. That's why, Lordship, unless.
But unless the delay is condoned, how can I
Lordship, when, Lordship, there is for passing of the injunction order, when, Lordship, there is a delay, Lordship, the court can, Lordship, part limited.
Order 41 Rule 3 capital A.
Rule 3
That's the
capital
bar.
A, but there is a provision, Lordship, provides.
Show me.
Order 39 Rule 3, Lordship, when, Lordship, the
What order 39 Rule?
Object, when the main object
You
to pass.
You want stay of the further proceedings of the execution case. Order 41 Rule 3 is a bar.
There is a bar, Lordship, but when Lordship court feels that there is a embargo just for the Lordship limitation, in respect of the limitation, and there is a urgency, Lordship, court can, Lordship, pass the order for stay or injunction. Court can protect the Lordship interest of the parties.
Mr. Sannal, the difficulty is that today you are mentioning. So the learned advocate will not be aware.
No, Vokalatnama also filed, Lordship. I checked from the Lordship status.
Difficult. It's difficult.
I also informed the counterpart before the learned court below, Lordship, to inform the other side.
Tomorrow I am keeping, please serve a notice upon the learned advocate who is appearing in the executing court. The list.
This is my application.
My lord,
I will not purchase the property from a person, but my lord, upon purchase, my lord, society, the building, my lord, did not allow me to, my lord, run it for a commercial purpose. So I filed a suit. My lord, during pendency of the suit, my lord, lot of immediate hearings happened, injunction application was heard. Ultimately, parties settled the matter. Matter settled, settlement agreement signed, joint application by all parties, my lord, made.
Number 30, yes. 61. 2861.
My lord, matter settled between, my lord, the plaintiffs and the four, my lord, defendants. My lord, joint application filed.
Who are you?
I'm the plaintiff.
Yes.
Joint application by, my lord, all parties filed under order 23 Rule 3, requesting the learned judge to dispose of the suit in terms of the settlement between the parties. The joint application filed under order 23 Rule 3 by all parties, matter settled. Well, the learned judge.
But the defendant filed the written statement.
Well, defendants have filed a written statement, but my lord, all parties have filed an application, matter settled. I'll tell you, Lordship, my lord, what happened. I was personally there. It's not pleaded, my lord. I've kept it out of the pleading unit. The learned judge, my lord, said, go for mediation. So, my lord, we were perplexed. Why? Matter settled. What is there to mediate? Parties are settled.
Well, please show me the application under order 20.
Said that she get points. The judge, my lord, suggested that she get points if the matter comes to mediation.
Please show me where is the application under order 23 rule 3.
Lord, the application is at page 138. And the annex settlement agreement, Lord, is at page 144.
144.
Yes, 138, Lord, is the. Lord, my reading of the room was, Lord, we angered the perhaps, Lord, the learned judge, and so not sure. 138, Lord. The prayer is at 139. This is by the two plaintiffs, joint application by the two plaintiffs and the four defendants. And the only other defendant is a pro forma defendant against whom there are no press, no reviews. I'm praying
So-
for the suit to be defeated.
So I'm directing on 6th of October this application be taken up for hearing. So order 23 rule 3 has to be heard.
Yes,
A decision on that. So I'm directing on 6th is the next date fixed. I'm directing on 6th this application to be taken up and an order be passed.
Lord, may I only, my lord, suggest this? My lord, the parties will come before lordship if required. My lord. If your lordship-
Here it cannot be done. Order 23, I will decide that application here. Ashok.
Lord, then can it be done earlier? My lord? Liberty may be given, my lord, to mention. And my lord, because my lord, I have paid money, extra money, my lord, on maintenance.
This application under Article 227 of the Constitution of India.
settle between the parties, between the contesting parties, because
between the contesting parties. Settle dispute involved in the suit has been settled between the parties, the contesting parties. Yes, next. You are appearing. Oh, 30. What is that? If it is service, why? There was a caveat. Then why have you served? Feruddin. Yes. Yes, what is it? You are appearing. Yes.
Item number 31 and 138
Yes.
arise out of the same suit.
138.
My lord. Now in 138, my lord was pleased to pass an order on 3rd July 2026.
Who is appearing in 138? Samrat Chakraborty.
Sir Roy, Honorable Justice Roy was.
Yes. Where is he?
Where is he?
Mr. Where is Samrat Chakraborty? Call him.
What I intend to do is, subject to your lordship, this is an application essentially for expeditious hearing. The parties belong are brother and sister. Not what I was humbly beseeching your lordship. Any day, if it commends to your lordship, if both the matters be taken up, because I will not be trying to steal a march over anyone with Mr. Chok.
No, you want this suit to be disposed of. That I can pass a direction.
That your lordship may, but that would not serve the purpose. This is essentially to expedite 138 also. The 138 essentially has stalled the suit. If your lordship sees your lordship's order.
138 of the
day's list.
Yes.
The order intends that no further proceed. They have taken time for
provisional preliminary degree.
Yes, and then they have taken time in the learned code below on 3 occasions. They have taken time even today, I'm told, by Mr. Mukherjee. What I was saying.
There was a possibility of settlement. What happened? There is a settlement.
That is incorrect. That is not a correct position, factually.
So I'm relegating before that honorable judge who said that there was a settlement. He's the best person to decide on that.
Correct. বলছে শুন না কি বলছে I will try to effect service. সম্রাট এসছে I'll effect service on Mr.
Where is he?
Sir, he is engaged in courtroom number 37.
37. Ask him to come. Mr. Bhattacharya, I'm passing it over 245. Ask him to come. দুটো একসঙ্গে রেখে দেবেন.
Take back the order.
So you order to Yes. Yes.
I have filed a for declaration. The net 60 court at Calcutta, I will come to the order dated 7/2026, my lord.
2nd of July 2026.
Yes, my lord. On that day, my lord, order of injunction was granted. On that day, the plaintiff has filed an extension petition, and that day was fixed for hearing of orders of the Code of Civil Procedure application. On that time, my lord, the judge asked for the personal appearance of the plaintiff. By commission of right. That day, she was not present in the court. She had the earlier morning, she had the necessary signing and filed the immediate extension of additional order of injunction.
Yes.
And my lord, on that day, the learned judge, my lord, has vacated this identity order of injunction without any hearing.
If it is vacated, it's an appellable order. How can a revision be entertained on that? Ad interim order of injunction is vacated. It's an appellable order.
Without any hearing.
Maybe.
My lord, without any hearing.
Without hearing, with hearing, everything is appellable order. Together, 33 and 34 একসঙ্গে দিন তো 34টাও দিন 34
Order. Last page.
of 33 same matter. Yes.
The order was denied. This is for further order, petitioner files Sajida, market documents. Instant case disposed of about 3 satisfaction and the order of the learned affiliate passed by the learned affiliate by the way, that the order passed by the by the in the year and before filed by the 19/12/2024. See that the position of the district of the and by beginning of draft, non-raised objection and the also your signature of the position of the succeeding insurance but this order has been passed without looking at the order that against the order of the appeal court. Already on divisional application filed. This order will have that divisional application if they have already filed cabinet, they are present. An order has been passed that the government court directed that the matter should be heard out. I should point of law, I should heard out the matter. Then I pay for state court said at that time, okay, I shall get out the matter. And this matter has to be nothing that's not already the market is that was during that, without knowledge of that,
There was any order of stay.
the stay has not been.
Then there was no impediment upon the executive court to execute that. Then,
I pay for stay that situation.
so it's up to you whether you will withdraw it or not. But how can this be reversed? If the possession has been taken, you succeed, you will get back possession.
Because my lord, this order has been passed without taking consideration that already and
civil division case has been maybe, but civil division application, if there is no stay. Their knowledge and malady your loss. Maybe, but if there is no stay, there is no bar in proceeding. Mere pendency of a civil division application does not. But since this your lordship get the order of passing this. Here only execution has been allowed. You have been given liberty to withdraw. If you want, if you don't want to withdraw, I will record that. That in view of the pendency, you don't want to withdraw that. But that possession, it cannot be reversed now. No, possession has practically, it is since it has been not in the knowledge of the petitioner, he even doesn't know that the matter has been taken up for debate. In each and every after the order, preemption order, which has been passed by the without giving any notice to this order. That is also my point. You are the preemptee. Yes. What is your challenge in the civil division application? On what point? Your lordship kindly come to page 50? 52 of this. The order of this order. No. I'm asking you, what is the point in stage yard parcel? Stage yard parcel. Yes. Yes. Here she has played short preemption. And without. Since I'm not inclined to take up this matter on personal ground, this matter. I've released it 2132 and please keep the other number.
Right, please, ma'am.
The other matter. Plus also your lordship's court that another civil division. Yes. That is in respect of the in the contested application, only one is appearing. Yes, though it is analogous. Mention that to be mentioned. Where is that? There is a bench for hearing. Yes.
My lord, item number 35, my lord, I am appearing on behalf of the opposite parties, my lord.
Item number
35, my lord. Caveat was there, my lord, because
35.
yes, my lord. We have been
Yes,
served.
Mr. Mukherjee.
My lord, may I just pray, my lord? Copy page.
Caveat was there. You have not served.
My lord, yes, my lord, we have been served, my lord. What I'm praying, my lord, may I pray for a short adjournment for a fortnight, my lord. My lord, we, in the meantime, we are also preferring, my lord, a revisional application, my lord.
Challenging the self-same order.
Not challenging per se, but there is a certain observation, my lord, which is prejudicial to our interest, my lord. That is why we have been instructed to challenge, to seek a revisional application, my lord. My lord, in the morning, as you lordship may recall, my lord, I came to seek leave to file application without the certified copy, my lord. My lord, we are in the process of procuring. My lord.
Yes, Mr. Mukherjee.
At the threshold, we are challenging the filing of the revocation application in respect of cancellation or revocation of a grant, which happened in 2010. According to us,
in respect of a grant, you have filed a revocation application.
But the opposite party has filed a revocation application.
Yes.
But in the application for revocation itself, I can show or demonstrate before your lordship that the knowledge regarding the grant and the subsequent mutation on the basis of the grant. Why not I am saying or
What are you challenging here?
he has not filed a demerger application stating that on the face of it, if the revocation is not beyond 3 years, applying Article 137, then it's not lengthened.
One important thing, may I have the leave to interject, my lord. My lord, perhaps my lord, my learned friend, my lord, is aware, my lord. The petitioner is the holder of the probate, the second probate, my lord, my lord. They have no locus to challenge this, my lord.
Please wait. If you are ready, I will hear you.
No, my lord, I just.
Yes.
There are two grants according to the subsequent, the last will of the testatrix is being probated in my favor. The last one. Subsequently, they pleaded in their revocation application regarding the knowledge of the grant, subsequent mutation granted by the municipal authority on the basis of the grant, and almost a lapse of 8 to 9 years thereafter, the instant application for revocation is being filed with all these pleadings. So ex facie, according to us, the ex facie is not maintainable. It's beyond the period of limitation. That application of mine is being dealt with and rejected not by the trial judge.
So well-reasoned order, Mr. Mukherjee, covering about 9 pages.
Order that I must say, but
yes,
only without giving the details with regard to the facts that has been pleaded by both the parties, but that is not necessary. In my respectful submission, if I can place before your lordship the revocation itself application, it will be evident that now that your lordship was Article 58 and 59 is now recently been interpreted by the Honorable Supreme Court. I am stating that if a particular instrument is being given effect to, and subsequent mutation in the record of rights is like a public notice, and on the basis of that, merely pleading that I can here, he came to know also.
Where is that?
Yes, kindly take some. I shall show only that. The page, it starts with page 47. Kindly takes up paragraph 7. Thereafter, thereafter, on or about November 2014, it came to the knowledge of the petitioner, much to its shock and surprise, that the opposite party fraudulently and illegally had caused to have his name mutated for the said property in the revenue records maintained by the Kolkata Municipal Corporation on or about 13th November 2013. The revocation case is of 2023. The petitioner immediately issued letter dated such and such to the KMC, bringing to its notice to its that it was in fact the lawful owner of the said property and had been in legal possession of the said property since in the year 2007. A copy of the letter that so and so is annexed. Now, on or about 31st October 2018, the lease of the ground floor of the said property expired, upon which it became incumbent upon the lessee to hand over the physical possession of the ground floor of the said property to the petitioner. However, the lessee failed and neglected to do so. In such circumstances, the petitioner issued notice dated 15th of May 2019, calling upon the lessee to vacate the ground floor and to make over the vacant possession to the petitioner. A copy of the notice dated such and such is also annexed. The lessees responded to the said notice dated 30th May 2019 by its reply dated 15th June 2019, intimating his refusal to hand over vacant possession of the ground floor and illegally questioned the petitioner's title to the said property on various untenable and misconceived grounds. A copy of the said reply is such and such is annexed. Now, the lessee in the said reply, as your lordship got it just after the annexation, the lessee in the said reply internally wrongfully and illegally claimed that the opposite party who had been illegally and wrongfully claimed title over the said property under the alleged second will, pursuant to grant of the second probate in his favor, had purportedly been in touch with the lessee and was seeking to regularize the tenancy of the lessee under him. Now, that if your lordship skip and comes to another important.
Where is the knowledge with regard to that grant?
My lord.
Where it has been stated?
Look, there is not in paragraph 7, kindly takes up now paragraph 14 also. Wow.
Yes.
Subsequently, the petitioner on the advice.
No, Mr. Mukherjee, please show me that their knowledge, statement about their knowledge with regard to the grant. Where is that?
Paragraph 7 and paragraph 8 is the only statement made with regard to this.
Paragraph 7 and 8, paragraph 7 and 8 is with regard to the, they say that it has been mutated, but not with regard to the grant. So whether it was on the basis of a grant or not, that's not their admission. There is admission is only with regard to mutation.
That is precisely where I am on. The Honorable Supreme Court recently made his judgment, the 2025 volume 5, is page 198.
My lord, we have.
Here,
don't have a bigger device.
Yeah.
Mr. Mukherjee, what are you doing? You are still with that smaller device.
My lord, we have made necessary pleadings in the application, my lord. If only we have an opportunity, my lord, we can present, demonstrate, my lord.
Where is that? The bigger. Nowadays, we are taking those smaller device.
My lord, if given an
There
opportunity.
will not also, the knowledge was not pleaded. It's not an illusory thing. But the deed executed sometime in 60s, after decades, not suit initiated. Wherein the Honorable Supreme Court stated that your saying will not do. Once the deed was acted upon, the kind takes up this judgment, paragraph 12 onwards.
My lord,
Article 58 and 59, that's the discovery. And it takes up the, it's originated from order 711 itself. Takes up paragraph 12 below.
Mr. Mukherjee, this revocation proceedings, what would be the limitation?
my lord, we are going deep down
It
in.
does not
Even
say.
the landed judge also.
Yes,
Even the landed
58
judge-
and 59.
No, I am not on. I am not on that. Article Miller, I am not. I am on the principle. I am on
Which
the
paragraphs?
Paragraph 12 onwards, the topic takes up. I say, Milord, he cannot sit back and sat tight over the issues. He himself stated in 2013 the revenue records have been corrected. He issued notice to the KMC.
My lord, with your lordship's leave, my lord, I am saying, my lord, we have sufficient answers, my lord, pleaded in the applications, my lord, my lord, my lord.
Sir, I will come back to you. Yes.
And Milord, paragraph 14 also of their Milord revocation application, where they
So you are relying upon paragraphs 12, 13, and 14. These three paragraphs.
according to me, Milord, this cannot be a thumb rule. You cannot say.
So according to you, it has to be assumed that he had notice of that grant.
Yes. Where I am on. The learned judge cannot, Milord, learned judge, with due respect, has not gone into, Milord, this aspect of the matter.
What is the recent decision on the period of limitation for revocation of a grant? Recent decision of the Honorable Supreme Court. I think 7 to 10 days back.
But Milord, applying
On this period of limitation.
if Milord applying that Milord judgment, wherein Milord, if I do have a knowledge with regard to the execution of the will, But that judgment where once the application for probate is being filed and thereafter for technical reason.
Division bench
Yes.
judgment you will be relying upon.
That's the logic. But if that is there, then he cannot come go around roaming around for 10 years and after that merely 2023 file a revocation application. This aspect of the matter has not gone. According to me, this should be looked into by in a cursory manner. The learned judge can always say, no, it's not bar. But he has taken aid of entirety COVID period. I am not on COVID period. If I can satisfy that his period of limitation starts from 2030, relying upon these 3 paragraphs of the Supreme Court judgment, then he cannot take advantage of 2020 COVID. By that time, the 3 years long.
My lord, one important thing, my lord, I must point out, my lord, relying upon the judgment passed by the Honorable Supreme Court, my lord, we say, my lord, the second probate holder, my lord, have no right at all. Probate holder, my lord, my learned friend is the second holder of the probate, the second probate, my lord. We have been, our client have been issued a probate earlier in time before them, my lord. So we are saying, my lord, the second probate is a nullity in the eye of law, my lord. So there,
which will is the subsequent one?
my lord,
And
we have taken sufficient pleadings in the my lord, in the application, my lord, in the court below, my lord. Given an opportunity, my lord, we can certainly demonstrate, my lord, how we say they do not have any right based on the Supreme Court's ruling, my lord. Time and again, Supreme Court had stated that the second probate holder is a nullity. Second probate is a nullity, my lord. Given an opportunity, my lord, in this matter, my lord, we seek an adjournment of a fortnight, my lord, so that we can collate everything, my lord, and in present to you, my lord.
Fortnight I will forget.
A week, my lord, as your lordship pleases, my lord. My lord, we are also in the process.
Difficult to remember all this.
My lord, we can apprise, my lord. Of course, we will apprise, my lord. It's our duty to apprise, my lord. My lord, we are in the process.
Stay the revocation hearing. That is
My lord, we have also, we are also preferring an application, my lord, regarding certain.
So you are challenging what?
That observation with regard to the limitation.
So you are also proposing to challenge this.
Not the order
of certain observations.
Certain observation, yes, my lord. My lord, so only we are procuring the certified copy, my lord.
So then if both of you challenge, the proceeding should not go on.
My lord, we will seek an adjournment, my lord. The next date is 3rd of my lord. My lord, only let there be an adjournment, my lord. No order of stay, my lord.
No.
My lord, if my lord,
to be hard, sir.
My lord, can let it be posted, not today, my lord. Let it be taken up tomorrow, my lord. Otherwise, my lord, we will be prejudiced, my lord. I pray before my lord, my lord.
Tomorrow,
my lord, as your lordship pleases, a week or tomorrow, whatever, my lord, whatever suits, my lord. I leave it to you, my lord, because we are in the process of challenge. Otherwise, we will.
If it is tomorrow, something will be kept in my mind. Otherwise, it will wash over. Hard, Mr. Mukherjee.
Obliged.
এটা দিয়ে দিন। Application under Article 227 of the Constitution of India.
For the petitioner and paying for expeditions for a match filing 2020
Who are you?
and for the husband.
Husband, any order for alimony pending today?
There is one order for alimony pending, but
You are complying with that.
yes, my lord, because no, the higher amount is the yes, I'm paying that for the husband as per order of this honorable. Takes the order as well.
You are not a defaulter in payment of any.
Yes, yes.
Then expeditious hearing cannot be passed. This application under Article 227 of the Constitution of India. Husband.
In 31, I have filed one revisional application that is running as item number 138, my lord. That's why, my lord.
Yes, there is any chance of settlement.
But I have to take instruction, my lord.
That was your submission on
Yes,
the last occasion.
Yes, my lord. Well, kindly-
Yes. Now what should be done?
State 130 file for a moment.
So, my lord, I do not have that brief today, my lord.
আমি তোমাকে দিচ্ছি।
Thank you, sir.
আমার আইপ্যাডটা দিন।
How can this be allowed provisionally? Application is provisionally allowed subject to.
Petition finally sees the nature of the order, which is under challenge in 138. I'm reading it for your lordship. today is fixed for hearing of Order 12, Rule 6.
Yes.
Referring to the admission as to the shares of the parties to the suit in the suit property as mentioned in page 5 of the written statement filed by the defendant. My learned friend's client is for the defendant. On 13/11, the plaintiff paid for preliminary decree on admission declaring 50% shares each to the parties to the suit in respect of the suit property. Learned advocate for the defendant contended that although the defendant has no objection regarding the division of shares of the parties in respect of the suit property, but defendant is entitled to the costs incurred by him for maintenance, protection of the suit property from time to time where the plaintiff made no contribution.
Mr. Bhattacharya, I have appreciated that. But the question is, if there's an admission, why provisional decree? It should be a final preliminary decree. Why provisionally?
Provisional, I do not know where the word
Then-
provisional comes from.
If both of you admit that 50% preliminary decree has to be passed,
My lord.
what, my lord?
My lord, my lord, yes, that.
But
with
that
provision-
direction is there. Please
Mr.
see.
Bhattacharya, I'm keeping it tomorrow. Let
Very
it come.
good. Tomorrow,
My lord, I'll
Please
come
take
prepared.
instructions.
Yes, yes.
tomorrow, one matter is already to be mentioned. This matter. One matter, in the morning I mentioned that is to be, that is not of course.
You have a choice. Which one to
No, no choice. Let both the matters be tagged together tomorrow.
And
That must be not one
this-
sentence. এটা দিয়ে দিও। expedition কপিটা দিয়ে দিলাম।
31 টাতে next matter.
Nine. Nine
Yes, yes.
is.
My lord, I appear for the opposite party.
Now please see the nature of the interim.
Well, what is the extreme urgency? Lawyer's urgency.
No. I tell you, Lordship, what is happening. And the matter need not
Section 24, transfer.
Need not open the paper. Husband's Act 8 suit.
Who are you?
Right. Husband's Act of 2021. Wife's matrimonial suit under Section 27 of the 1954 Act is of the later period. One is pending in the 4th Additional District Judge, the other is before another learned court in the same court, Alipur. My lord, since 21 till date, not a farthing paid towards maintenance of the child. There is a child born out of the wedlock. The wedlock took place in 2009. The child is born in 2016. She is presently, my lord, 10, 11 years old, staying with the mother. The father has filed application, my lord, in his application, certain rights, visitation rights, my lord, which we have questioned by way of an application pending before the court in question, 4th Additional District Judge. No. Correct recording in his. Now, my lord.
He has not read the brief.
No, he has read it.
He has read the brief.
Junior, my lord. It is just incidental that, my lord, I am appearing about. Actually, they are more. I mean, what has happened is, in course of this, there are two various proceedings. No maintenance paid. I take out an application before the court below.
In the matrimonial suit.
In the matrimonial suit. Praying for transferring both the suits to the same judge. So that multiplicity is avoided. 1, 2, on different dates, I am working lady. I have to take out a sustenance for myself and also the child. The father is not paying a farthing. I am not for myself. For the child, at least, the child is entitled to some, fodder, nothing is being paid. good, bad, indifferent, my lord, the learned court below, the learned district judge Alipur on 18th of June rejects my application, saying that I have questioned. One of the reasons ascribed by him is I have questioned as to what the nature of order. My lord, in the maintenance, I'm sorry, my lord, in the custody matter, my lord, in the guardianship wards act matter, my lord, there are certain orders which we have questioned by way of applications seeking recall. So therefore, I had treated that in my, my lord, 24 application and paragraph 5. The learned district judge feels that I have, since I have pleaded it in paragraph 5 of my pleadings, I am not entitled to any order insofar as transfer is concerned and has rejected my transfer application under section 24. Now, my lord, my only submission today here before your lordship, I am not.
So what is the
Well,
difficulty?
let him finish,
Both
my
the-
lord. I am.
both the two proceedings are tried.
No, no,
by
no.
the same court.
Let it be tried by.
Let him finish, my lord. Let him finish, my lord. Well, what are the grounds for rejection, my lord? I will come to that, my lord. Let him finish, my lord. I will make my.
No, I'm
We
not
both
only
because
saying if two proceedings.
no, my lord, what
are
has
pending
happened?
before the two courts? So if those are, I'm not saying analogously, but if it is before the same court, if same dates are fixed, so it will be convenient for both of you. What is the difficulty?
My lord, there are two grounds, my lord, which are taken in this application.
Forget about the
One is that overlapping.
convenience of the court as well as the parties. If those two proceedings are transferred to either way, either the guardianship to be transferred to the
One is
court
before the
back-
fourth court, another is ninth court.
Yes, anyone can be transferred to the other court. He does not have a choice. If you have a choice, you can tell that.
My lord, the difficulty is that he is not complying with the order passed by the.
That's on merits. I am
The
not on that.
visitation is not given.
No, he is not complying with the orders passed by which court?
By the ninth court.
No,
Fourth court. Fourth court.
Fourth court is where the matrimonial suit is.
No, where the Act,
All right, so
Act 8 proceedings is
so the
pending.
matrimonial suit will be transferred to that court. It is not objecting to that. What difficulty?
Yes,
you have?
yes, yes.
My prayer was, I leave it to the court. I am saying both the matters should be heard by the same court.
Yes.
But it can be transferred to the fourth court, my lord. My I've taken instruction.
Regarding one issue. My lord, though this is not for that matter. My lord, since my very
Yes.
nice friend is appearing,
बहुत
I am
बहुत
only
भाई थी
requesting.
আমাকে पुलिस ने
No, okay,
अरे बॉल बॉल
Mr. Aniket Mitra, when he is appearing, I can, my lord, try to tell this to your lordship. Though this proceeding is not there, I am aware about the position. But if some maintenance, something has to be made over for the child. I will not be at liberty to pray for appropriate.
That
in this application I cannot, my lord, agree.
the Mitro cannot commit
In this
something
section
from
24 application I cannot, my lord.
the application is pending. If you have taken out an application, that will be considered in due course.
Application and whatever applications pending be also decided expeditiously by the court to which it is transferred.
My lord.
Where is the impugned order?
My lord, it is order dated 18/6.
Certified copy?
Page है, no, certified copy.
I'm a
By 18
order
June,
number 3 dated 18 June.
18 June 2026.
Page certified copy.
May the certified copy, my lord, the lordship will. It's not paginated.
153, I'm told.
153 हो जाएगा
Certified copy.
नहीं ये ठीक है ठीक है हाँ हाँ
Certified copy?
সার্টিফাইড কপি হতে হবে তো তাহলে কি করে ফাইল
So you have prayed for from fourth court to ninth court.
Yes, that is where the divorce is pending.
Fourth, my lord, custody matter is pending. Ninth court, divorce proceedings is pending.
Well, I have prayed for that. But my lord, on instructions, my lord, of course, oral instructions. I'm not with the client, not from the client, but from my instructing friends, my lord. I have no issues, my lord. Any court, but both together. And all applications to be disposed of at the outset, before my lord taking up the hearing.
Yes, because their objection is that since the fourth court has passed certain orders, they do not want.
My objection.
It was their objection, it is not our objection.
So they had pointed it out to the learned district judge. Their paragraph 5, we have quoted some. Please see the page 4 of the internal page 4 of the order passed by the court.
But there are two issues which they have raised. One is regarding, my lord, whether these two proceedings are overlapping and interconnected. And the other one is, my lord, some aspersions have been made.
Let both the matters, it is arising out of the same wedlock. Child is born out of the wedlock.
Fourth court.
My lord.
The court is very much insisting in production of the child, The child is at, was produced in the court. The child openly said, though, it can be said whatever, she's a 10-year-old child. She has said that I don't want to meet the father. And the child has not seen the father since she was 5 years old.
No, since you have made that allegation,
So that
the Honorable District Judge was.
That might have prompted. I agree, but I told you a lordship. That weighed with the Honorable District Judge. Then another sentence more, just pardon. There are applications pending, which needs to be decided first. One sentence in your.
You have paid only one court fees, Mr. Bhattacharya. That is for challenging the order rejecting transfer. Expeditious.
227.
No. Everything, my lord, cannot be in one application.
Another application, it will be beneficial to you.
Maintenance application, if they are
No,
required.
maintenance, my lord, cannot be.
Sentence.
No.
The learned thank you.
I'm obliged to you.
Yes.
লিস্ট অফ ডেটস তৈরি করতে পারে আমরা একটা হিস্ট্রি নিয়ে সেটা এটা জজকে দেওয়া যায়
Yes.
কতগুলো ডেট এর জন্য হচ্ছে সব লেখা আছে But I had told my juniors to prepare list of dates for your lordship's convenience. And most of the dates on this list of dates are irrelevant.
Are irrelevant?
No, it starts from 1994.
That is what they're dragging it.
Please mark it from where it is relevant. I shall proceed from there.
But I just give your lordship the relevant dates. May not be required. All the dates may not be required, your lordship within the time. I'll just indicate to your lordship, my lord. If your lordship is first looks at the third date, serial number tao.
Yes.
This is one relevant date, 2004. So, my lord, the opposite party is the licensor. The license given for a period of 6 years. Kindly see, my lord, 83.
You are the opposite party.
I am the opposite party landlord. I'll indicate to you, but just I'll take 2 minutes. So, we're at 83,800 square feet of commercial space. Now, my lord, he gets into possession, is enjoying the property. Thereafter, my lord, there was an issue relating to the original property was given on lease to the landlord opposite party by Kolkata Port Trust. So, my lord, Kolkata Port Trust lease was not registered at that relevant point of time. So subsequently, because this was a court proceeding, court sale, we got the property from company court sale. So there was orders passed from time to time, which we eventually went to the Supreme Court, and Supreme Court said, AOPD execute the lease. Pursuant to the Supreme Court order, lease was executed. But the lease execution was after the execution of the license agreement. In any event, we had the authority under the original lease agreement to grant subleases. Be that as it may, he was in possession. Now, my lord, the agreement, the license agreement contains an arbitration agreement, which is in the nature of a clause. My lord, at that relevant point of time, when he was in possession, my lord, he invokes the arbitration proceeding and initiated the arbitration proceeding, saying that the landlord, his landlord, my clients, doesn't have the authority or did not have the title to let him out. This was more towards the end when the lease was or the license period was coming to an end. My lord, an award was passed. That award was challenged by us, set aside. When it came before the division bench in appeal by them, in a 37 appeal before this court, the division bench specifically held that, my lord, that he has been in possession. So 116 estoppel against tenant applies. So if he challenges my title, first he has to hand over possession to me under 108Q. So eventually 37 appeal dismissed, Supreme Court dismissed. Then I have to get back, recover possession from him. So my lord, I initiate arbitration proceeding. Now that arbitration proceeding was contested, all points taken, including, my lord, including the point which they are selling now. Once again, that same point that I don't have title. Eventually, an award is passed in my favor for recovery of possession. That award was challenged in a 34 proceeding before the district court, commercial court. Dismissed. Appeal before this court, dismissed. Supreme Court, dismissed. So the award, so far as recovery of possession is concerned, has reached a finality. Now, my lord, I have to take back possession, so I initiate, I enforce the award, filed execution proceedings. So now this execution proceedings, in the execution proceedings now, my lord, he has taken a stand, which we will come to later, my lord. In that execution proceeding, he has filed this application in the nature of a section 47 application, and his only point is that he had filed a suit. But he had filed a suit in 2018 or 2015, I stand corrected. Now, what is the suit he has filed? He has filed a suit, that same point, that I do not have his landlord.
Same point meaning?
That landlord does not have the right to let out the property to him.
Challenging the lease deed pursuant.
Also the lease deed which has been granted to me pursuant to the Supreme Court order. Now, in the 47 application, his only point is, which I am sure, I am told that subject to correction, that Mr. Sen, who was appearing for the petition, has said that this is his only point and nullity is not a point that he is arguing. That order 21, rule 29, that the executing court is entitled to grant stay because a suit is pending. This is the principle which he has argued. His suit is admittedly pending. So till the disposal of his suit, the execution cannot proceed. His 47 has been dismissed. Now, my lord, the present divisional application. My lord, without taking much of your lordship's time, my lord, two things your lordship will see. One, if your lordship will kindly take certain admissions, if your lordship takes the section 47 application,
The impugned order is rejection of section 47 or order 21, rule 29?
no, my lord. There, 47, the point in section 47 was order 21, rule 29. No separate application.
All right.
So this 47 has been dismissed.
Where is the...
My lord, kindly take page 192. This is the application that they filed.
Section 47 is in 2 volumes.
Well, 22 years of litigation, and the interesting thing is, if I tell your lordship,
Only 3 pages is in the next volume.
3 pages in the next volume. So first volume has, I don't know the because I have a soft copy. So, and the second volume has only 3 pages.
No, 3 pages of this application.
Oh, acha, 3. No, 1. Very well. Now, the irony is, in the executing cause, he goes and says that he is not in possession.
What is the admission?
I'll tell you. This is, if they have not disclosed, in the execution proceeding, the same execution proceeding, he has filed an affidavit stating that when I told your lordship there was division bench, appeal, section 9. In those proceedings, what happened? High Court has appointed receivers. 2 things. My lordship can take judicial notice of this. High Court appointed receiver, initially appointed by the district judge, reaffirmed by the High Court, directing the receiver to ensure that no further person is inducted. He's basically letting out the entire 88,000 of godown space and he's earning from there crores of rupees. List, preparation, inventory, who all are there, everything. And not to make payment of any rent to the petitioner, who was the licensee tenant, and to collect the rent. So his case is that I am not in possession, receiver is in possession. So this is the stand that he takes in the execution application. So then why are you defending the execution proceeding if you are not in possession? And my lord, and interestingly, my lord, there's no reference of this in the petition application. My lord, kindly take one paragraph here where he says that.
Of that affidavit in opposition.
Yes, my lord. To the execution application he had filed. জায়গাটা বলো।
Yes.
Immediately after the table at internal page 3 of the order, para 4. Internal page 3 of the application, paragraph 4.
Yes.
No. I state that on perusal of the various reports filed by the special officer, contained list of occupants found to be in occupation of various portion. It can be verified that the respondent company has not been in possession of any part of the premises since as long back as in 2016.
Yes.
And my decree, deemed decree, of course, award. So he says for recovery of possession. So why are you resisting possession? Why the application to start with? Now, my lord, kindly come back to the application which I was drawing your lordship's attention.
47.
Yes. Kindly come to my lord, internal running page 193, paragraph 6.
Yes.
This is his application. He says, pursuant to an order of April 2003 as modified by the order of 2004 passed by the High Court at Calcutta, KOPT was directed to execute a lease of the decree holder upon the decree holder clearing all areas of lease rent due from such and such to KOPT. Subsequently, by the order of 8th May 2006, the Honorable Supreme Court directed renewal of the lease with effect from 4th August 2003. Has your lordship found that Supreme Court order? Now, my lord, kindly have a look at the previous paragraph where he says how he was inducted. He was inducted by a agreement of 2004. My lord, immediately the paragraph thereafter, your lordship will see.
Yes.
Even prior to such direction being passed by the Honorable Supreme Court, the decree holder had inducted the judgment debtor under an agreement of such and such for a period of 6 years commencing from such and such.
Yes.
So the matter went up, it was being pursued before this court, then it went to the Supreme Court. Supreme Court said execute the lease retrospectively from.
Thereafter, no renewal. After 2011, no renewal.
No, his lease has expired by efflux of time.
Thereafter, no renewal.
No renewal.
With an option to renew the same on mutually.
No. Terminated. Terminated. Thereafter, expired by efflux of time, arbitration, award passed, everything done. Then your lordship will kindly take once paragraph 9 of the same application.
Yes.
However, it subsequently transpired on an application by the judgment debtor under the Right to Information Act that the aforesaid representations were wholly false and contrary to record. By a reply of 2011, KOPT categorically stated that they have never granted any lease or tenancy in favor of the decree holder. In the previous paragraph, you've said Supreme Court, pursuant to order of the Supreme Court, a registered lease was executed.
Yes.
And you say that I don't have any right, title and interest. In the previous paragraph, immediately the previous paragraph, you say the registered lease has been executed pursuant to the order of the...
Reply under the Right to Information Act.
No, then he makes the Right to Information Act response. He says that based on the response, he says that the representations made by me is false.
Yes.
So if my representation made by me is false, then the statement made by you in paragraph 6 that the Supreme Court order of which you had knowledge, they had knowledge of everything, be that as it may. This is the conduct and this is the basis of the application. Now, my lord, your lordship will kindly take paragraph 12.
Yes.
That the legality, validity and binding effect of the purported lease of 2015 executed by KOPT in favor of the decree holder is the subject matter of challenge in title suit number 36 of 2022 before this learned court, wherein the same has been assailed. So, my lord, it is not before this learned court. My lord, kindly pausing here for a moment. My lord, this is before this suit of his original suit, if your lordship kindly has a look at the front, it was filed before the City Civil Court at Calcutta. And the executing court is the Commercial Court at Alipur.
Now the suit is pending before the commercial court.
So now the original suit was filed before the City Civil Court at Calcutta. Now, my lord, if your lordship will see, if your lordship can have a look at the plaint at page 126, your lordship can take notice of that.
Yes. I don't think they will be disputing that.
No, they are not.
But
Yes.
pending before the commercial court.
Now, my lord, if your lordship now straight away comes to the impugned order.
Yes.
तो बोलो दिए commercial court pending है.
Yes.
Now, my lord, if your lordship will kindly straight away come to internal page 11 of the impugned order. This is.
Yes.
My lord, it records previously, my lord, the 34 award, 34 Supreme Court thereafter. The award impugned is an eviction award, thereby directing the award to hand over vacant and peaceful possession. The award debtor itself repeatedly acknowledged in the pleadings and affidavits that the award debtor already vacated the subject property and no longer in possession thereof, particularly in the affidavit in opposition of 18.
That was taken note of.
Yes. Filed by the award. While considering the instant application, the court has also taken consider the ratio of the judgment of the High Court at Calcutta in FMAT 744. My lord, kindly have a look at this portion which arose out of the my lord, which they have not annexed, my lord, need not be annexed, but your lordship can see the quoted portion. My lord, kindly come to internal page 13.
Of this judgment.
Yes, my lord, internal page 13.
Yes.
Where, my lord, that MMTC judgment, which is the applicability of section 47 in case of arbitral awards which are deemed decree and its applicability is different from that in a civil suit decree. That has been considered. Then, my lord, kindly take the next page, section 116 of the Evidence Act, page 14, after the quoted portion.
Yes.
Therefore, while considering IS such and such, this court has to be restrained within the four corners that delineated by the Honorable Supreme Court in the aforesaid judgments. Judgment data's case falls within the arena of nullity or fraud. This court is now delving into such aspects. Now, my lord, kindly see. The award in the instant case raised an objection to proceed with the instant section 47 apply on the ground of the bar of 116 of the Indian Evidence Act. 116 quoted then. My lord, then the next page after the quoted portion, in the instant case, it is admitted position that the award debtor was inducted by the award holder as a licensee under the subject property. Thus, the award holder was the landlord of the award debtor, and after admitting the landlord-tenant relationship, award debtor has paid monthly license fees such and such. Therefore, in view of the fact that the award debtor should be stopped from disputing the title of the decree holder in terms of the above stipulation of the Indian Evidence Act, in that proposition, this court intends to rely on the ratio of Jaspal Kaur. This is 2017 8 SCC. Then that portion is quoted. Then, my lord, kindly come to well, in fact, if your lordship can, then we don't have to trouble your lordship with that judgment. That paragraph 10 is quoted.
Yes.
which will be towards the bottom of page 15, internal page 15 of the award. Your Lordship can make a note of that, my lord. It says this section deals with estoppel of a tenant founded upon contract between the tenant and the landlord. It enumerates the principle. Well, I need not trouble your Lordship with that. Then, my lord, kindly take where the quoted portion ends at page 17. The aforesaid proposition is also grounded by the Honorable High Court in the order of 20th May 2016. But this was the previous round, not this award, previous award.
Yes, sir.
Now, my lord, kindly see the relevant portion. It is the same proceeding, or between the same party and the same agreement and the same proceeding. My lord, kindly see the division bench findings. In any case, well, at bottom of page 17, in any case, Start Track, which is the present petitioner, having been inducted by Efcalon, which is the opposite party landlord, in terms of a license agreement, Efcalon is estopped under 116 of the Evidence Act from questioning the right of Efcalon. Efcalon should be not Efcalon, that should be Start Track. Yes. This is the quoting mistake. To the possession of the said premises. It is further to state that the three issues as raised by the award debtor in IF 5 of 2026 have already been considered by the arbitral tribunal in the impugned award itself at paragraph 36. She refers to the paragraphs. Then even the award debtor specifically pleaded at in the section 34 and 37 application that such observations of the learned tribunal are misplaced and accordingly challenge the same. This was a challenge in the 34 proceeding. Affirmed, appeal, Supreme Court. Then, my lord, kindly come to then that Rahul Shah paragraph 42.8.
Directions to dispose of.
No. That is the scope of that intervention under to what extent 47 will be applicable.
Yes.
That Rahul Shah, that earth-breaking report. Rahul Shah judgment. Lord, if your lordship will see, quoted quote page 12.
Yes, frivolous applications not to be entertained at a time limit fixed in disposal of the.
Yeah, in fact, if your lordship just comes up a few pages up at page 12, I think the relevant portion is quoted of para 42.8 at page 12 of the judgment itself, the order of the impugned order. Page 12, if your lordship comes back towards the middle of page 12, your lordship will say in bold, Rahul S. Shah, Supra, and then para 42.8.
Yes.
No, my lord,
so the directions are contained in various sub-paragraphs of paragraph 42.
Yes. And my lord, what is relevant for our purpose, which was relied upon by us before the trial court, was 42.8.
Writes in a mechanical manner.
Further, the court should refrain from entertaining any such application that has already been considered by the court while adjudicating the suit, or which raises any such issue which otherwise could have been raised and determined during adjudication of the suit, if due diligence and exercised by the applicant.
Yes.
So, my lord, what we are respectfully submitting before your lordship is these issues has been raised not once, twice. Once in the previous round, thereafter when I started the arbitration, once again before the arbitrator, which has also held against them in the award 34, 37 Supreme Court. So 2 rounds of Supreme Court has already happened. Then, my lord, coming back to the order 21, rule 29.
Yes.
Now, my lord, according to them, since their suit is pending, so, my lord, they should get the benefit of order 21, rule 29. My lord, our first respectful submission before your lordship is that, my lord, in case of a deemed decree, the principles of rule 29 of order 21 is not applicable to start with. An award, my lord, it has been held is not a decree. My lord, it has the trappings of it, it's a deemed decree. My lord, that legal fiction has been, my lord, there's a judgment of the Supreme Court in Abdul Samad, where, my lord, the executability of an arbitral award was being considered based on, my lord, the award passing or decree passing code and 39, whether the executing court will be the court where the property is situated, or will be the court where the decree has been
Suppose we have
passed.
an authority which says that in an execution proceedings for executing an arbitral award,
Yes,
Order
well.
21, Rule 29 will not be applicable, or none of the procedures under Order 21 shall not be applicable.
No, my lord, not, which does
Because
not
there are
say
decisions which
21.
say that provisions akin to or principles of the civil procedure code shall apply.
No,
May
no,
not
what-
be in strict sense.
in strict sense.
But the principles may apply.
So our first point is that since it's a deemed decree, first principles, Order 21, Rule 29 does not apply. Number two, what you are raising in the suit, well, this has been decided not once, twice in proceedings initiated or defended by you. So that squarely comes within the purview of 42.8 of Rahul Shah. Now, my lord, the third point, if your lordship will see, there is a 72
But
Supreme
how
Court.
this has been dealt with by the executing court, Order 21, Rule 29? How it has been dealt with by the executing
My lord,
court?
estoppel principle, I have already shown your lordship, my lord.
Yes.
How the court had dealt with that estoppel principle. It had relied upon all the judgments, and thereafter, my lord, at Order 21, Rule 29 principle, my lord, it starts at, if your lordship will kindly come to page, number, if your lordship kindly comes back to internal page 18, 1-8. In fact, towards the middle, my lord, where Rahul Shah has been mentioned, immediately the one after that.
Yes.
Under Order 21, Rule 29, this court is vested with the discretion to stay execution of the award pending a decision in the prior civil suit between the same parties. But it is to state that such power of the court is discretionary and cannot be claimed as a matter of right by the award debtor. Now, upon considering the aforesaid delineation, this court does not find any such case as made out by the award debtor, so that this court shall execute such discretionary power vested under Order 21, Rule 29. It is reiterated that all such issues raised by the award debtor in IA 05 of 2026 have already been taken into consideration by the High Court in the order of 20th May 2016. My lord, the relevant portion, my lord, is quoted. My lord, kindly take that.
IA 5 of 2026 is Order 21, Rule 29.
No, it is there is no application under Order 21, Rule 29. The only application
IA
is
5 of 2026 is what?
47.
Oh, that is 47.
There is no Order 21. They apply the principles of Order 21. Now,
Yes.
that is another question. Whether can you apply the principles of Order 21, Rule 26 in a 47 application? Even assuming for the sake of argument that you can, because otherwise this will give right to another round of litigation. Then, my lord, kindly come to that quoted portion. My lord, this will give your lordship the answer. My lord, on top of internal page 19 of the impugned order. In any case, it is a fundamental principle of law as enunciated in section 64 and 65 of the Contract Act that a party rescinding a voidable contract is obliged to restore the benefits derived from the contract. Even if a contract is ab initio void, all benefits received thereunder would have to be restored. There can be no dispute that even if it is assumed that Star Trek's agreement with Efkalon was voidable at the option of Star Trek was still obliged to restore all benefits which Star Trek derived from the license agreement. Having been inducted by Efkalon, Star Trek cannot and does not have any independent right to occupy the said premises, far less any right to let out the premises and earn occupational charges from the said premises. Well, just pausing here for a moment. Your lordship will be surprised to note there's a mean profit decree which is under execution, and the total value of the mean profit decreased 90 crore. Not one single penny has been paid. If it is assumed that license agreement was void as contended by Star Trek in the arbitration proceeding, Star Trek would not be entitled to retain the benefits it derived from the license agreement. In other words, Star Trek would have to refund occupation charges earned by Star Trek by further subletting the said premises to the occupant. In any case, the award having been set aside and an appeal filed in this court from the judgment and order setting aside the award having been dismissed, Star Trek cannot claim the benefit of the award. This was his arbitration proceeding. In any case, Star Trek having been inducted by F-Colon in terms of a license agreement, F-Colon is estopped.
Again,
under
116 coming.
116 of the Evidence Act from questioning the right of F-Colon to possession of the said premises. And my lord, I'll just show your lordship apropos this, the prayers in their suit. Prima facie, it appears that Star Trek was not entitled to remain at the premises or utilize the premises to earn occupational charges or rent or subletting the premises after termination of the license agreement. Even assuming that the license agreement had wrongfully been terminated, the license was for a period of 6 years, commencing from such and such to October 2011, extendable for a further period of 3 years by mutual consent between such and such. Star Trek has been in possession of the premises for over 10 years, expired such and such, the license agreement not extended. Even if the license agreement was renewed, the license agreement still agrees such and such. Then, the license agreement having expired, Star Trek is obliged to restore possession of the premises to F-Colon. We cannot but take judicial notice of the subsequent development of 23rd June 2015, when Kolkata Port Trust executed a deed of lease in favor of F-Colon, whereby Kolkata Port Trust leased out the said premises to F-Colon for a period of 30 years from August 2003.
Proceedings were after the suit.
Mr. Bose,
My
the
lord.
next paragraph quoted portion, please turn over to the next page 21.
Yes, my lord.
The first sentence. Is there a typographical mistake with regard to the date? Page 21, first sentence, first line, 4th of August 2013. Is it a typographical error?
Yes, yes.
2000.
Whether it should be 2003?
2003.
Relies on this division bench judgment, relies on the lease deed passes the award.
Yes.
So all this is taken into consideration in those 4 paragraphs referred in the impugned order of the award, 36, 37, 38, 30. So this is all referred. That previous round, division bench, estoppel, 116, they can't be input, everything considered. And my lord, it specifically records the division bench that the lease granted by KOPT in my favor pursuant to the order of the Supreme Court retrospectively. And my lord, just my lord, kindly, my lord, wait. Kindly have the suit that they now refer to for the purpose of, my lord, attracting the provisions of Rule 29. My lord, kindly have a look at the relief in the suit. My lord, the suit starts at page 126. And your lordship will find the reliefs are at page 142.
One 26.
No, my lord, it starts, yes, my lord, the relevant portion of the suit where the relief starts is at page 142, 142.
Yes.
Suit is of, my lord, kindly lordship can make a note. Suit is of 2015.
Yes.
So everything is subsequent. The division bench order, the subsequent orders, everything is subsequent. So how the suit is still in the record of the court, that is also, my lord, something which is interesting to note. Kindly see the declaration prayer, the first declaratory prayer, a decree for declaration that the plaintiff has a right to enjoy the premises number such and such along with such and such electricity such and such at Taratola, Kolkata without creating any obstruction, then my lord B. Declaration that the lease of 23rd June 2015 registered in the office of the Registrar of Assurance.
What is that lease deed?
The lease deed which was executed in my favor pursuant to order of the Supreme Court. The division bench of the High Court, my lord, records in that internal page 18, that operative portion has been quoted. He says that lease deed should be declared void, is invalid. So a lease between X and Y
challenged by Z.
And who? A tenant who is inducted by X to whom is being.
Yes.
And he shows this to be the, and this is his only, my lord, effectively the only ground on which he invokes the principles of Order 47 and says that, so my lord, we don't wish to expand this application much further. Really limited scope, my lord, that your lordship will find in the impugned order itself. I'll just give your lordship the paragraph. যেখানে MMTC পোর্শনটা কোট করলো কোথায়? Well, at internal page 13, your lordship will find
internal page
1(3) of the impugned order.
Yes.
Your lordship will find there's a reference to a judgment of the Supreme Court in 2026. Huh? না আরে ইলেকট্রো স্টিল বলছে, এটা তো আছে MMTC টা, এটা তো MMTC, তাই তো
electro steel.
No, my lord, there are
electro steel.
Yes, my lord. My lord, it is quoted, my lord, unnecessary দেখিয়ে লাভ। আচ্ছা ঠিক আছে দাও। It's quoted, so I thought that, my lord, instead of troubling your lordship, my lord. Lordshipকে দিয়ে দিন। My lord, these two judgments are quoted, then the subsequent MMTC, which refers to electro steel, that has been also quoted, that's in 2026. Para 69. My lord, kindly have a look at para 69. Take a look.
$29.
69, my lord.
69.
69.
Yes.
Section 47 deals with questions to be determined by the court executing decree as per subsection 1. All questions arising between the parties to the suit in which the decree was passed and relating to the execution, discharge, satisfaction of the decree shall be determined by the court executing the decree by separate, the law well settled, limited to the ground of jurisdictional infirmity and voidness. Then, Banat, that Basudev has been quoted. My lord, kindly take once 70. Objection to execution of an award under 47 is not dependent or contingent upon filing of a petition under 34 of the 96 Act. The High Court was not justified in taking the view that since the appellant did not file a petition under 34, therefore it was precluded from filing an application before the executing court to declare the award as void and non-executed. This is on fraud.
That was the issue.
Yes,
if you have not filed 34,
correct,
whether you can file 47.
Now, in fact, the amendment has come in fraud. When it is a fraud, even you can file it beyond the period of 120 days. So now, my lord, if you
fraud vitiates everything.
Yes, it does. And my lord, his only case is I did not have title. And my license is saying this is the limited scope of this application. And in fact, the next judgment is quoted at internal page 13, my lord, MMTC, which is 2026. The narrow compass. It's there, my lord. In the impugned order, your lordship will find page internal page 13. If your lordship, we can give your lordship a copy of the judgment as well. In case, my lord. This is the 2026 3 SCC page 99.
Courts electricity.
Yes. And my lord,
Paragraph
Electricity 22. It refers, my lord, in the impugned order itself. Narrow
paragraph
compass
22.
2-2, my lord.
2-2.
Relied by them.
70.
Yes. Anything more, Mr. Bose?
My lord, there is one more principle that, in fact, Order 21, Order 20, Rule 29 of Order 21 has no otherwise also. Anything apart from all this is because it has to be before the same court. Post the amendment, my lord, there is a 72 Supreme Court which says that it has to be before the same court. Only then the
In Order 21, Rule
decree.
29.
Yes, my lord. Such court, that has been defined. If your lordship will see the language. Pending থাকলে হবে না
In any court.
No, that's such court that your lordship will see where a
Whereas
suit is pending in any court
court
against the order or decree of a court or the decree which
against
is
the holder of a decree of such court.
Yes. So it has been interpreted so the jurisdiction can only be invoked when the decree passing court and where the suit is pending between the judgment date and decree holder has to be the same court.
You have a
In
decision
fact,
on
well, this amendment was brought in based on the 72 Supreme Court judgment. But 72 Supreme Court, 1972, 2 SCC 731.
9. Which paragraph?
My lord, kindly first take
such court explained.
Paragraph 6 first. Then, my lord, kindly come to where 29 towards the bottom of paragraph 6. Your lordship turns to the next page, yes. Where Rule 29 deals with a different situation.
Context of that rule, the court in which the suit is pending. In other words, the suit must be won. Not only pending in that court, but also won against the whole.
Then there's a paragraph immediately after that. It is obvious from a mere perusal of the rule.
Yeah.
And my lord, also consider paragraph 7.
You want to take paragraph 16. Rate care and only under special cases. The discretionary remedy and the court can put him to terms.
We don't want any terms.
Discretionary का देखिए देखो ये पता है. Even if it is
Absolutely, absolutely.
So this application has to be filed
if at all.
before the court where the suit is pending.
No, it is the, if subject to correction, my lord.
That's the
The
finding in
court,
paragraph 7.
yes, well,
Please
can you
kindly
see para
come to
7?
paragraph 7.
Yes, my lord. It is true that in appropriate cases, a court may grant an injunction against a party not to prosecute a proceeding in other court.
In some other court.
Some other court.
Yes.
But ordinarily courts, unless they exercise appellate or revisional jurisdiction, do not have the power to stop proceeding in other courts by an order directed to such courts. For this specific provision of law are necessary, Rule 29 clearly shows that the power of the court to stay execution before it flows directly from the fact that the execution is at the instance of the decree holders whose decree has been passed by the court, by that court only. That court only.
If the decree in execution was not passed by it, it had no jurisdiction to stay the execution. That means the application under Order 21, Rule 29 has to be filed before the court where the suit is pending.
Section 41 specific relief act.
Right.
Before the court where the suit is pending.
Right.
Not the executing court.
No, what I am saying is that the decree passing court, the court that passed the decree also, if your lordship kindly looks at the language.
This language is otherwise. It says, because it starts with a court cannot pass stay proceedings before other courts. If you read conjointly, this says in the suit, if you have to stay that, it has to be the court where the suit is pending, not the court.
So if your lordship applies the principles of section 41 of the Specific Relief Act to this situation.
Order 21, Rule 29 says
yes,
that it has to be before that court.
That court.
Where the suit is pending.
Correct.
The suit is pending. If the decree has been passed by that court, it can stay execution by that court, not other court.
So if that is the principle, then his application in any event was not maintainable. In any way, this was a 47. Anyway, whichever way, this is an additional point that we've taken apart from the fact that the application is otherwise thoroughly misconceived. So we're not considering all this and the...
Because this has been filed in the executing court.
Yes. In my execution.
Yes.
This is an application filed in my execution.
Yes. So in view of this judgment, this point could not have been taken in the execution case. It can be a ground in that suit.
Possibly the next round.
Should not have referred to this.
Yeah.
That gives Mr. Sen some.
Yes.
Initial again.
Different
battlefield. Of course, again.
In fact, my lord, this 72, 81 Supreme Court, if your lordship will consider now 81 consider 72. If your lordship comes back.
Remedy at a
In fact, if your lordship once again takes para 7, but since it is that deemed decree principle is here because it's from an arbitral award.
Or we will make our submissions on this aspect. But I think there is some scope of submission on this.
No, but it is a discretion. Even if your application was not maintainable, it was still a discretion.
Tell from your lordship in which court it has to be filed. I think, my lord, we shall have to.
No, court.
So your lordship will kindly consider the language of 29 months. And also another aspect, whether a suit court will be competent to stay another proceeding. Will it not be in conflict with the?
But this is 72 SCC says that, paragraph 7.
I'll consider that, but that concept of being barred under the specific factors.
No, even then, Mr. Sen, if it is not that, that is for you to take before other forum. So far as this is concerned,
Yes.
so you have filed in the executing court.
I filed it.
So you cannot say it's not maintainable before the executing court.
Yeah. No, my lord, even
Academic response to your lordship.
Yes.
even if I assume it is maintainable, question is that 29, rule 29 is the discretion. So the court has exercised the discretion. Now the question is that whether such a discretion, to what extent
was properly exercised or not.
And my lord, it
Anything
has
more
referred to
propose?
nothing else. It has referred to multiple, my lord, the previous proceedings before the court where the same issue on which today they are asking for stay has already been decided. আরে কেন তোমরা মাল্টিপ্লাই করছো একটার পর একটা দিয়ে যাচ্ছে 16 বলে দিন যেকোনো কোনটা দেয়
Great care and only under special.
Well, this is in fact, if your lordship has been handed over 81 Supreme Court, this takes into consideration Shaukat Hussain, which is 72 Supreme Court, at paragraph 17.
Yes. It has been relied upon.
Yes. And my lord, also your lordship can make note of para 16. Where the court was amazed, kindly say 16 also. We are rather amazed to find that the totally unwarranted plea taken by such and such seems to have found favor with the civil judge who readily accepted the prayer of staying of the execution of a decree without realizing the scope of Order 21, Rule 29. Under this provision, jurisdiction has to be exercised with very great care and only under special cases. And then, my lord, kindly take para 17. My lord, this.
Yes.
Which had passed the decree to stay its execution.
Yes.
These are my respectful submissions.
What more?
I have not made, but they said that they will take 10 minutes. And I will have to deal with the judgment.
What judgment?
What my learned friend has cited.
This is on order 21, rule 29.
The first day of order 21, rule 29, that the learned judge did not exercise the discretion required to do under
Supreme Court judgment.
earlier facts not relevant. You only have to see what is the subject matter of the suit which is pending. If there is a communality in the subject matter of the suit and the subject matter of the decree, then you will have to exercise discretion under Order 21. This aspect has not been adverted to at all by the order.
You can file a short notes.
Give me 10-15 minutes. I will just read.
Mr. Sen, it's difficult now to again fix. You have made your submission. Mr. Bose has not, he has only relied upon the decisions which were referred to in the judgment. Only he was overexcited to place these judgments under Order 21, Rule 29. So it says, but it's.
But after all, a point of law, my lord, kindly do not leave us only to filing of notes. 10 minutes, your lordship.
No, here, even if that is so, you have filed the application before the executing court.
Yes.
So that application has been decided, it was not rejected on the ground, it's not maintainable.
No.
So that's it now. If according to you, that it's maintainable before that suit court, that's up to you.
No, I'm not saying, I'm not, I am taking as it is maintainable before the executing court itself.
Yes,
But
that's
Kindly permit me to make a submission on the judgments which he has cited.
Judgments, those are been relied upon in the impugned order. He has not relied upon any new judgments.
Just give me 10 minutes. Otherwise, I will be at a disadvantage. I have to make some submission.
এটা এখনই আছে 10 minutes আছে What? না না
The problem is fixing the date. That's the problem.
There are only one thing, Miller, I shown your lordship the Supreme Court order where it says that the execution is required to be disposed of within 4 months. And the 4 months, no, I am saying 4 months is coming to an end in September. Mana, now he says he's not in possession. Now, but he goes and every day showing the pendency of the revisional application for
Yes, so
four adjournments they have taken.
I must get a time to make a reply.
No, my lord, then if you are not in possession, why are you obstructing my execution proceeding? Let the execution proceed.
Showing my lord's order. I must get a chance to reply.
কাল অ্যাপ্লিকেশন মেশন করছি
আরো অ্যাপ্লিকেশন ফাইল করেছে
না না এই রিভিশনটা আমরা মেনশন করেছি তো
হ্যাঁ ন্যাচারালি
Naturally.
it did not appear on the date was fixed.
Mongolbar.
But you have a junior who
Nahi.
wears the style of two Ramkrishna.
Tuesday, Mr. Sen. Asun. Mr. Bose, learned senior advocate, appearing.
I don't want that stigma.
আরে কিছু বলেনি তো
না 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 আরে এটা দেখিয়ে টাইম হচ্ছে
tomorrow. He says he's not in possession. He says, I've shown your lordship affidavit.
This matter is being hard.
We will
What then I have to pass an order?
No, don't. We will take steps. Kindly don't, man.
Yes. Yes, call the next matter.
Huh? তিনটে ফিক্স আছে ফিক্স আছে না
just remind your lordship, Lord,
অন্যটা তো ফিক্স হয়েছে তিনটের সময় ফিক্স হয়েছে এটা 4:15 তাহলে তিনটের সময় এখানেই ফিক্স হয়েছে ACS.
But I'll just remind your lordship,
Very
Lord.
good other side.
Yes, Mr. Basu was appearing, Lord.
I am for the opposition.
You are here.
Yes.
Yes.
On the last occasion, there are certain directions.
Mr. Basu.
He's coming here, Lordship, on this way.
He has left.
No, he's coming here, Lordship.
Yes.
Certain directions on the special.
Let's just, Lord.
Half of the receiver. Last time, my lord, your lordship had directed the receiver to appear himself or to a advocate or virtual. Receiver is online also, my lord. I'm appearing.
You are representing him. Yes.
My lord, first I would want to start, my lord, with tendering my apology on behalf of the receiver, my lord. The advocate, my lord, enrolled in 2003. He has made a mistake.
He has been?
He has made a mistake. But the accounts were to be submitted bi-monthly. Has, for whatever reason, my lord, did not file on time. My lord, he has, in the meantime, my lord, on 13th of August, filed all the accounts. The entire thing has been filed for the work order. August, my lord, tendering unconditional account. You know, this one is fine. I can't give any excuses, my lord. He should have filed it on time.
First order.
The lordship's order of 22nd September 2025. Your lordship will file the last 4 lines of that order, 22nd September 2025.
September.
That we have annexed, your Lordship, in the Can 1.
Can 1.
Yes, your Lordship. Page 16 of Can 1, your Lordship will get that order.
But I
Can 1, your Lordship, in CO number 3330 of 2025. 3330 of 2025, Can 1.
I will see the order. I don't know which page the order would be. I have a
Page
copy of the
16.
order.
Page 16.
Lord, I have a copy of the order, 22nd September 2025.
Yes.
The lordship turns over to the second page, the last 4 lines of the order. The receiver is directed to keep the accounts of
Yes.
the daily
Periodical accounts bi-monthly before the learned trial judge.
He had kept it, but he had not filed. It is a mistake.
That was prepared.
It's been prepared and now, my lord, he has filed it
on 13th of August, before the learned court below, I have prepared, my lord, what has been filed. I have prepared also.
Opinion.
I'll hand over.
Please give them copies.
I will kindly take page 15. Page 15. My lord, this is the order which records, my lord, that the monthly accounts from September 2025 has been filed, and from page 16 onwards, my lord, is all the accounts on a daily basis. Everything is there.
देखिए मैंने account
Till July. And my lord, it's a mistake. The lordship tells me, my lord, I have told him that I can't see him.
2025 এর
my lord, he tenders unconditional apology.
দাঁড়া accounts টা কবে থেকে দিয়েছে?
It's been a mistake.
So only one thing your lordship kindly sees, your lordship, the index. He has given your lordship the accounts.
He's an advocate enrolled from
I understand your lordship. Kindly see the index. When from when?
My lord, he told me, my lord, apart from this matter, he's a receiver in only one other matter. He's a regular practitioner.
No, lordship, index, lordship, kindly see the index from when he has given the account.
That may not be necessary, my lord. I am addressing your lordship on merit.
Index, your lordship, of the report. Accounts from September 2025 till 2026. We don't know, your lordship, the accounts from where your lordship he was appointed.
No, but prior to that, the order records that was submitted.
That's why
Please,
the previous order.
please see the previous order. Where is that order?
Previous order, if your lordship takes page
Dakar.
1. Where preliminary
My instruction, your lordship, from 1st of April 2023 to September 2025, your lordship, the receiver has not filed any.
No, please see this order
Yes.
records, order dated 13th of August 2026.
13th of August.
Page 15.
Files reports, monthly account report from September 2025.
So your lordship, order was 22nd September.
Excellent.
Daily accounts to be kept from 22nd September and up to 31st July. He's filed that report. My lord, your lordship, if there is anything else required to be done, he will do. My lord, he has a remuneration of 10,000 rupees every month. And that also, my lord, gets adjusted. From what I find, the hotel, I don't think is making that much of money. Well, all accounts have been given on a daily.
2023 order ta dekho. And मुझे 2025. Further files.
Filed it in court.
Lordship, kindly take page number 2, your lordship.
Have
Once.
been appointed as the receiver from when?
Yes.
16th March 2021.
So from that you are also preparing the accounts.
Those are not daily accounts which were prepared at that time. Because
No, may not be daily, monthly, yearly, half yearly, quarterly, anything. Where is the opening balance?
Lordship takes page 2.
How could you prepare an accounts of the month
Just
of
lord, told
September?
my junior lord that
Lordship, kindly-
it is before a judge who is also a chartered accountant.
Lordship, kindly take 17th March order, your lordship. 17th March order, your lordship, kindly take.
Let me try and establish.
No, no.
Kindly just
Yes, certainly is a
Accounts,
duty cast on
preparation
him.
of accounts. So something has to be done from where you start.
The lordship will take page 1.
17th March order, your
Preliminary
lordship, kindly
account
see.
report is filed. This was on 30th April 2026.
No, I am on 17th of March 2021.
Starting point, since when you were appointed
Yes.
as a receiver, so you have to
But
see
20
May I show you,
months of
17th
that.
March.
How can you prepare an accounts in this form?
Has filed account before also.
Filing in what manner? Is it an account? Have you checked up?
From 22nd September, I have, after your lordship's order. Prior to that, from the
Copy
orders
then.
which are there, your lordship will kindly take page 1 and 2. There are 2 orders.
From September, so you are continuing prior to that. So from September, even if it is accepted that this go direct from September, where is the opening balance? How you prepare an account? Is it the way of preparing an account?
Well, he had prepared daily accounts on a daily basis. Whatever was coming, if your lordship tells me, I will get.
Cannot be said to be an account, sir.
I will sit with him again, my lord. He's in Asansol. I'll sit with him. I'll see whatever is there. Is
Cannot be an account.
The opening balance will start from 17th March 2021 when the order was passed. And that the closing balance for that particular financial year, your lordship will come on 31st.
My lord will.
These accounts cannot be accepted.
From the beginning. from the beginning. I'll start with him, my lord. I'll see whatever is there, what he has filed from the beginning till 22nd September. I will get that. If it has not been filed, what I find that he has filed something prior to that. Prior to 22nd September 2025, he has been filing some accounts over monthly.
Even if that is fine, even if we accepted, take your submission at face value,
I see
then you must be having something which was the closing balance, which you will take as the opening balance.
Yes.
When he has taken over
there is
your lordship.
nothing. You start from 1st of September. You know, it's not the way of preparation of the accounts.
আমি জানি এখন ও তো
Profit deposit করা
Lordship, kindly, your lordship, once your lordship take the 17th March's order. That's the order when he was where he was appointed, and there are certain duties casted upon him. And a copy to dao yaar. Not only keeping accounts, your lordship, kindly see the next page. The learned receiver is directed to administer the suit property with due diligence, fairly and faithfully, and to submit monthly accounts of profit and loss before this court. The first line, your lordship, in second page. The learned receiver is further directed to deposit all the amounts of profit whatsoever related with the proper administration of a scheduled suit property in the court by challan, which will be withdrawn after the disposal of the suit.
Not been prepared in.
And now, your lordship, he wants to file it.
Money deposit after 1 week. I will sit with him personally also and see whatever is there, we'll file. He's a practicing advocate. I don't, well, from what I came, what's come across to me, I don't think, well, he has tried to pull a fast one on the court or anything, well, he's a practicing advocate. It's one matter, there are two matters where he's been appointed a receiver. This is one of those. It's not like he's, well, a regular receiver also. Well, I will kindly give him 1 week time. I'll see whatever he has prepared. Whatever documents he has, I will get it. If I think there is something which is already filed prior to 20.
Yes.
Yes. Your lordship will kindly come to Lord the prayers. Lord, on the last occasion, Lord, I was just trying to.
Not for complying with your lordship's order from 22nd September, the bi-monthly tendering unconditional.
Sir, tendering unconditional apology is one thing. Receiver is responsibility is much more.
I absolutely agree with that.
And more so for preparation of the accounts. And this is the way. And their allegation is that you are not preparing.
I filed the can 1, your lordship, on that basis only, that the particular receiver should be discharged.
In the can, I have come on the basis of the order, my lord. I'll take a copy of the can and see whatever allegations are there.
Please have a copy of the can upon
the copy.
I will file a report, my lord, on the basis of that. I'll file a report to the best of whatever I can, my lord, after.
And this is the accounts which has been prepared, I think within 3-4 days. Not prepared from that.
The accounts prepared by advocates will be like this. Your lordship will not expect an accounts prepared by a chartered accountant that way.
Mr. Mukherjee, it's not that. But it has been prepared after this order has been passed.
Lord, I am told,
I am told.
That is why I was looking.
No, it was submitted. No, the court's order record that it was submitted. But may not be not from the date when it was supposed to be submitted.
I'm told, my lord, he had intake accounts in his hand. I asked for his account fully up on that.
That I could gather from after going to the account.
Primarily from what I find, the primary accounts is beyond the expenses. Well, there are 3 staff members that found out all the details. I'll prepare a report and file.
Yes, Mr. Mukherjee.
But my basic argument before your lordship, I'll just, Lord, by way of Lord, reminding your lordship that Lord, the suit was filed for Lord, a perpetual injunction. Lord, on 2 counts.
Filed the suit.
No, my learned friends, Lord, I am the defendant. I am the defendant. But to say that Lord, the termination letter concerning his appointment as a manager was Lord, that was Lord, the subject matter of Lord, the challenge in a perpetual injunction. And Lord, there was a revocation of a general power of attorney. Lord, these two are Lord, the principal prayers. I'll just read Lord, the prayers before your lordship to understand why my contention about Lord, the maintainability is a prime concern. Now, Lord, the plaintiff, the prayer A, that is at page 36, the plaintiff may be granted a degree of perpetual injunction against the defendant, restraining him from forcibly giving legal effect and a further effect to the invalid and illegal deed of revocation dated 24/2018 and the letter of termination dated 25/4/2018 and not taking any steps for forcibly removing the plaintiff from management and ostensible ownership of a scheduled property and entering possession therein, and mandatory injunction directing the defendant to execute a proper deed of sale in favor of the plaintiff in respect of a scheduled property on receipt of the balance sale consideration upon a declaration that the alleged deed of revocation dated 24/2018 and the letter of termination dated 25/4/2018 are both wholly arbitrary, malafide, fraudulent, illegal, invalid, void, and of no legal effect. So your lordship will find that there is no the specific performance of a particular contract has been prayed for here. Secondly, his principal prayers are for
Valuation 99.
99. 99. No specific prayer. His basic the point is the deed of revocation and termination. Your lordship will then kindly come to Lord.
And the effective prayer is mandatory injunction.
Mandatory injunction. Without any declaration, without any specific performance sought for. Then your lordship will kindly see Lord, the letter informing Lord at page 41. The revocation of the power of
41 is the prayer in the plaint.
Lord, I am in 3330. The first one. No. আজকে না আজকে পাঁচটা অবধি হবে আজকে।
প্রশ্ন ওঠেন।
Yes, Mr. Vasu.
330.
330.
So 430.
No, matter was fixed at 3:30. Your lordship has taken up the matter now. That's the reason.
I'm at fault. I took
tell
this
your
matter
lordship
at
that he was not
4:15.
rushing the lordship.
We like the fault of the court. We like it. It's not that.
He was rushing the court that your lordship should hear the matter. He took out the application. So now I am willing to do the matter, Lord.
বাইরে বলে মার খাবি দাঁড়িয়ে আছে সব Oh, my lord, I have been told, my lord,
Pinsir
the receiver
attack
has filed
from both the
not
sides.
with the court below, before my lord. When?
Lord, kindly decide on the.
No. I am on the first point first. Absolutely correct. Agree.
আসুন।
Some
You have, and every day you are mentioning for motions. Then
don't say these things.
every day in this week, I think in the next week also, from 3 p.m. this fixed matters. So if 1.5 hour is taken out from the daily business of the court, Mr. Basu, it's very difficult, I am telling you.
I can assure, my lord, I say half an hour is outer limit. Before that, I will come.
No. That you can say, but it's the court who has to understand. The time for the court to understand.
The problem will be, my lord, who will run the suit.
So that's the only difficulty. You could have got this matter disposed of because the initial order was more than a year back. What were you doing?
My lord does not know what we are doing. Every day, my lord is in the morning seeing what we are doing.
That's the only difficulty because I'm trying because the motions are pending.
No.
That is.
In every matter has an urgency of his own.
So yes, I cannot also deny because some matters are urgent. May not be all, but some matters are really urgent. I'm trying to.
Every matter has its own urgency.
Yes, because the daily motions which are being filed, thereafter those motions, then 1.5 hours, it's very difficult. আচ্ছা একটা
He is the international lawyer, and I am only Calcutta High Court lawyer.
Calcutta High Court
Yes, it is Calcutta High Court, sir. For your information.
8 তারিখ 9 তারিখ কি আছে হবে 9th list will be able to reach within 4 or not.
Can you make it 3:30 so that we can have an
hope
that will be
information, advance information.
And for hearing, for filing the report by the receiver, and for hearing.
Last request, make it 3:30. Let us hope there can be conclusion.
I will not take any upgraded motions in Mr. Basu and Mr. Mukherjee will be appearing. You assured that? Yes. Then
take Mr. Mukherjee's name.
But Lordship, before